Of the United States Court of Appeals for the 10th Circuit. Hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near and they will be heard. God save the United States and this honorable court.
Judge, I think you're on mute.
There we go. All right, let's get started with, we have one case today with this panel, and then we'll swap panels and commence with the rest of the cases a few minutes after the conclusion of this one. Our first case is 24-6227 Chieftain Royalty Company versus Enervest Energy. And starting with the appellant, is it Mr. Pence first?
Your Honor, we spoke yesterday and agreed that Mr. Isaacson will go first.
Okay.
And that I will follow. Thank you.
All right.
Good morning, Your Honor. May it please the court. I'm Eric Allen Isaacson. Hope to take about 5 minutes to make some points. Mr. Pence and I are united in the belief that the fee award in this case is excessive, although our approach to the issues are a little bit different.
And who's your client again?
My client is C. Benjamin Nutley as trustee for the Nutley estate.
Okay.
And the case is one that's been around for quite a while. I think the initial settlement and fee award were back in 2015. Judge DeGiusti awarded 1/3 of the common fund as attorney's fees, despite the fact that class counsel did not state their precise time and were unwilling to document it. In fact, said they didn't keep time records. This court reversed, saying you've got to apply federal law. Reversed saying you've got to apply state law, Oklahoma Supreme Court law on attorney's fees. And it looks like the Oklahoma Supreme Court requires a lodestar analysis. It remanded, and the Oklahoma Supreme Court in another case called Strack said, yeah, we require a lodestar analysis. The question in that case was whether attorney's fees in a common fund can be determined on the basis of a percentage of the fund or lodestar. The court says, percentage of the fund and lodestar both are useful. You can start with one or the other, but it's important that it be reasonable, and you got to check one against the other. The Oklahoma Supreme Court said that there's a strong presumption that the lodestar, the unenhanced lodestar, is sufficient. And it checked the fee award in that case against the unenhanced lodestar and said, whoa, it's way above that. That's suspicious. It also said that percentage awards can be reasonable if they're between 20% and 30% in a complex common fund litigation. The median is 25. Let's check the fee in this case against 25%. And again, the fee was way above what the attorneys would have gotten with a 25% fee award. What was Judge DeGiusti's approach? Was it to follow Strack and analyze the case first in terms of the lodestar amount and the amount that a 25% fee award would produce? No, he reaffirmed his original 1/3 of the fund, and he did it without following what Strack says you got to do. Strack says, check it against the lodestar, check it against 25%. 25.
Didn't he do that? Essentially, is your argument that Strack is a hard cap? What's the number?
No, I don't think Strack is necessarily a hard cap, but Strack says we rarely approve of a fee award above 1.5. You recognized in your dissent, partial dissent from the last time the case was up, that the lodestar is, there's a strong presumption that the lodestar is sufficient, and that the lodestar amount is objective. Well, if there's a strong presumption that the unenhanced lodestar is sufficient, there's got to be a pretty strong explanation to deviate upwards. And Oklahoma Supreme Court says we rarely have approved a lodestar multiplier more than 1.5. The lodestar multiplier in this case is lots more than 1.5.
Well, then what's the inadequacy then in Judge DeGiusti's explanation? If there's some delta where you can vary upward from the Strack range, why was the court's explanation of its rationale inadequate here?
Well, the
Abuse of discretion.
The explanation of its rationale was inadequate for a number of reasons. One, it didn't recognize that it's a truly strong presumption that should be rarely departed from, and it was basically backing into to justify the original 1/3 fee award rather than starting with the Oklahoma Supreme Court's presumptions. And it also was applying the multiplier to a much larger lodestar than was warranted. It's an $8 million lodestar as calculated by the court. Mr. Pence has some reasons to think that the lodestar was a lot closer to 5 million if you wanted to calculate it legitimately. And I'd like, if I could, to reserve some time for rebuttal, like 3 minutes for Mr. Pence and myself both, and to cede the floor to Mr. Pence to talk about the lodestar.
All right, thank you, Mr. Pence. Go ahead.
Thank you, Your Honors. John Pence on behalf of Appellant Danny George. The parties are in agreement now that STRAC is the definitive statement of Oklahoma law on the award of attorney's fees in a class action. And obviously, to the extent that STRAC conflicts with the prior case of Burke, STRAC would control. But in fact, there is no conflict with the STRAC standard, and Burke can easily be explained based on the new standard that time is properly included in lodestar. And what we're really asking there is that when we were asking, can you include it in lodestar, we're asking, is it properly chargeable to the class? It's includable in lodestar when it's helpful to the litigation. And the class counsel in Burke did indeed meet that standard. First and foremost, class counsel in Burke did submit his lodestar data. Now, the court did overcompensate him there without showing its work. But as class counsel, he had no control over what the court was going to do once he submitted his lodestar. Furthermore, there was no Oklahoma law on the award of attorney's fees in a class action at that time. Burke was the case that kind of established the law that it's based on lodestar in Oklahoma and that lodestar multipliers are modest. They really do exceed 1.5.
Can I ask you about that, Mr. Pence? And you and Mr. Isaacson have referred to Justice Winchester's discussion about 1.5. Is that soft cap or whatever you call it, guidepost, to remain in perpetuity? Justice Winchester was referring to the reported cases as of the time that he issued the opinion in STRAC. So let's say in 5 years, does that mean that we will again be confronted with, say, a multiplier of 1.85 or 2.15 that Judge DeGiusti had, and say, well, Justice Winchester said back in 2021, based on the reported cases that he was looking at, that any multiplier over 1.5 is rarely to be, not never, but rarely to be approved. How long do we subscribe to this benchmark in light of the fact that he was relying on historical information?
Well, Your Honor, I would say, at least in this case, the strong similarity between STRAC and this case, they were both gas royalty class actions. They were both hard. Well, the STRAC court found that case was very desirable, that it presented low risk, but that they did a good job and that there was no penalty implied in that fee award. They were not penalizing class counsel for making any error or mistake. Unlike here, where class counsel committed malpractice and made a frivolous argument to the district court when class counsel failed to submit any lodestar data in connection with their 2015 fee petition, the following 3 years of appeal were just a waste of time. And it's wrong to charge the class for class counsel's malpractice in failing to submit its lodestar data in 2015. And then, to double down by going scorched earth on the appeal, taking it all the way up to the Supreme Court. When the question presented was simply, what law applies in a diversity class action, and that the answer to that has been state law ever since Erie. So the amount of time that class counsel wasted on that first appeal, they're the ones that should have to bear that time. It was for their own. They were chasing their own attorney's fee. That, by the way, that is the fact that the fee that Judge DeGiusti has awarded 33% each time, 3 different times, doesn't cure that first fee award. That was wrong when made. That initial 33% fee award represented a 3.46 multiplier, and there is simply no way, getting back to your question, Judge Bacharach, there's no way you're going to square that with anything that was said in Strack. I mean, that was clearly beyond the pale. We may see a multiplier of 2 or 2.5, but 3.
That's water under the bridge. I mean, that was reversed. Here we are, based on, let's go to Chieftain 2 in where Judge DeGiusti, now Mr. Isaacson referred to, I understand one criticism is that maybe he started with a 2.15 multiplier rather than starting freshly. But, putting that argument aside, Judge DeGiusti didn't make the error that you're referring to in Chieftain 1. Here, now that we are in Chieftain 3, he did purport to rely on the statutory factors that is consonant with Justice Winchester's opinion in Strack. Now, one could argue that I don't remember Justice Winchester referring to low risk. I do remember he said that these large royalty cases in Oklahoma are attractive, to firms, which is true here. But one of the statutory factors is results obtained, and we don't know from Strack, what was that $56 million award to the common fund in comparison to the claim to the claimed amount, and why isn't it reasonable here for Judge DeGiusti to say, well, an award of $52 to $55 million based on the very limited upside for statutory interest, that factor, results obtained, that is required to be considered, was enough to justify his exercise of discretion. Why doesn't that differentiate Strack, and why do we have to find an abuse of discretion?
Well, my response to that would be because of the limiting factor of the lodestar analysis. Perhaps Judge DeGiusti has a basis for exceeding the 25% benchmark here because of what he views as 100% recovery. But Strack cautions that you have to also compare that to what would be produced by the lodestar method. And because I believe that none of that time spent on Chieftain 1, which after all was an incorrect decision when made, and the fact that it's now been kind of cured by the inclusion of that $3 million, I mean, it's kind of a circular question. We don't believe that $3 million should be chargeable to the class, and it ends up to, being $6.4 million when it's multiplied by 2.15, because that was, this court even said it in Chieftain 1. They said, we wish class counsel had done their homework on Oklahoma law, and that simply means putting in some lodestar data. But if that had been done,
well, Judge Hartz, I think, was referring to keeping contemporaneous data. Judge DeGiusti found that the reconstruction of the data is reasonable. I think we're bound by the clear error standard. So I don't know why that dicta in Chieftain 1 would preclude us from finding that Judge DeGiusti didn't commit clear error in approving the reconstructed time records.
Judge Kelly, your speaker's off if you wanted to ask a question.
Well, I can't see anybody. There's something wrong with the presentation. But
Can you hear?
I can hear.
Okay.
And my final point would be that I'm aware that this court awarded time to the lead plaintiff based on time he spent reviewing those briefs in Chieftain 1. But there's a difference between, not wanting to penalize a lead plaintiff for doing something he was asked to do by his counsel, and he didn't really know. I doubt he was aware of the Oklahoma fee law, and class counsel who should have been aware of that, and who could have avoided all of that time, all of that lodestar, if they had simply presented their lodestar in connection with their 2015 fee petition. And unless you have any further questions,
yeah, you wanted to reserve some time for sure. Okay.
Mm-hmm.
All right.
Judge, I just wonder, before we start, I don't want to be presumptuous, but Amy, do you think IT could help Judge Kelly? I want him to be able to see.
Yeah. It. So, Judge Kelly, if you go up to the view in the top right corner, there's like 9 tiny boxes that make up one box. And if you click on that, the second option is gallery. Do you have that gallery setting on?
Oh, Judge Kelly,
I can't
you're
hear
on
you, Judge.
mute.
You're muted. Can you unmute, Judge?
Judge Kelly, you need
There
to.
you are.
Yeah, I'm
Thank you.
unmuted. I'm trying to figure this out.
Okay, so do you see the view
Okay.
at the top right corner?
I've got I've got the judges and I've got Mr. Pence and Mr. Isaacson.
Okay, and do you have it in that should be correct. You should only be able to see the attorneys who are arguing.
Okay,
But you can see them now.
yes.
Okay, looks like
Okay,
we're
great.
good to go. Let's
Sorry.
hear.
Thank you.
Let's hear
My
from.
apologies.
Let's hear from Mr. Beckworth.
May it please the court. Your Honors, I'm Brad Beckworth, and I am one of the members of the class council here, so we'll be arguing on behalf of ourselves as the appellee. This case was filed in 2011 when I was 39 years old. I'm now 53. Judge Timkovich, we've been before you at least once in this case, so it's good to see.
Charles Dickens could use this case for a plot.
I agree, and I hope that this will be the last of it. Importantly, this is the first time that Judge DeGiusti's opinion on the fee issue will be looked at on the actual merits. And 2 of his prior decisions have come before this court on the merits. And when that has happened, he's been affirmed. One was the decision about whether the settlement should be approved and he should reject the attack against the settlement by these objectors. That was affirmed in Chieftain 1 when we went to rehearing en banc. And then in Chieftain 2, his merits-based decision on the incentive fee award was approved on the merits or affirmed on the merits. So here, I think we're down to a singular issue. And that issue is, did Judge DeGiusti act within his discretion when he followed this court's mandate and followed Strack to apply that law to the facts of this case and find that a fee percentage of 31.5% was appropriate in the face of a $55 million settlement? And the answer to that is yes, he exercised his discretion and acted within it. Just stopping there for 1 second to be very clear. The fee award is 31.5% of the settlement value, which is undisputed. This idea that it's a third is a little confusing because it's a third of the cash, but the fee award is 31.5%, and that's reflected in Judge DeGiusti's most recent order.
Mr. Beckworth, let me test that. Now, you say that he was entitled to go upward to 31.5%. In Justice Winchester's opinion on page 617, he talks about the normal range of the percentage of 20 to 30%. But interestingly, the opinion has a very specific trigger point for varying from that benchmark. And it's a prepositional phrase, with deviations from that range when the fund is extraordinarily large or small relative to the hours of work expended by the attorneys. That follows a discussion saying that when the common fund is unusually large, there's economies of scale, which would suggest that the percentage should be lower, not higher. And there, of course, we were talking about a common fund in Strack of $56 million. Here we're talking about either $52 or $55 million. So I didn't see anything in Judge DeGiusti's opinions, any of those opinions, to suggest that he was going to 31.5% or 33%, whatever you call it, based on deviations because the fund is extraordinarily large or small relative to the work expended. If he had followed that, presumably he would be going below the 20 to 30% benchmark, not above it.
Your Honor, let me respond to that, and I respectfully disagree on several levels.
Okay.
First, I know you're surprised by that. First, you have to go back and look at what happened in Strack, and we were amici in that case. We've tried a lot of the oil and gas cases in Oklahoma, and in fact, we won affirmance on a verdict against Sunoco on Monday from this court. The defense lawyer in that case at trial was the objector in Strack, so we're very familiar with it. What happened in Strack was pretty straightforward. There was a 40% fee contract, and the trial court extended that contract and said 40% was the class rep fee, 40% should be the fee in the case. And when you go through the Strack opinion, it's very clear that what the Supreme Court had trouble with was the court didn't go through the Johnson factors or 2023 factors as they're called in Oklahoma. Now, if you go back to what happened with Judge DeGiusti here, he did it right the first time. We asked for a 40% fee. His original opinion in 2015 says, I'm not going to just carry that fee forward. I'm going to go and do a fulsome Johnson factor 2023 analysis of all the factors. And he decided to downward depart from 40% to a third or 31.5. So that's the first answer to that. Secondly, when you look at what I think what you're pointing to is economies of scale, that's real. I do a lot of this. You're talking about mega fund cases. If it's $1 billion fund, then sometimes it's so out of whack if you had a lodestar of, say, $5 million. But that's not what happened here. In Oklahoma, just like in your opinions, and take Vulgaris, for example, which really Strack and Vulgaris are on all fours, the idea is to get to a reasonable fee. And either the district court has discretion or he doesn't. And when you have a range, that means you have discretion. Here, most importantly, differing from Strack is we had 100% recovery. I know that's true because I did it. And our expert report on that is not disputed. It was 100% recovery. That is the most important factor in Oklahoma on any court analysis, whether it's a lodestar or a percentage of the fee. The second most important thing is award in similar cases. And Judge Timkovich, when you look at Chieftain 2, for example, that panel looked at awards in similar cases for the class representative. The same is true here. This record is full of expert opinions by trial court judges and scholars and practitioners that say both before and after Strack, 40% is really the common fee in cases, no matter how big they are in Oklahoma. Yes, sir.
Yeah, but the problem with that, Mr. Beckworth, is Judge Hetherington, Professor Gensler, Judge Burridge, Dan Little, all of those affidavits were filed 3 years before Strack was even decided. And they all rely, none of those rely, they all rely on state district court rulings 3 years before Justice Winchester confronted exactly the same sort of analysis and said, we have a 40% benchmark that should be applied for this common fund fee award. And Justice Winchester said, not state district courts in Oklahoma and the 77 counties have very rarely approved it. We, the Oklahoma Supreme Court, have rarely approved it, and in fact, expressly rejected a 40% percentage award. And so I don't know why the affidavits, none of which included a single settlement or fee award more recently than 3 years before Strack was decided, would justify us deviating from this 20 to 30% benchmark. So so Judge DeGiusti seems to have made just a factual error by crediting those affidavits, all of which preceded Strack.
Well, Your Honor, I'm sorry, go ahead.
No, I just said, what am I missing? I might be missing something.
Sure, I believe you are, with all due respect. First, let's be clear about Strack. It's not a starburst opinion. Strack didn't say this is new law. Strack says we're looking at what the law is and applying it to the facts of this specific case. Again, courts either have discretion or they don't. Strack cited this court's opinion in Brown. This court also cited Brown in Vulgaris. In Vulgaris, the objector tried to do exactly what they tried to do here and say, oh, if you look at this court's opinion in Gottlieb, there was a 25% benchmark because the court in Gottlieb talked about 25%. This court said, nope, that's not right. We didn't adopt a benchmark. The range is what it is in Brown. It can be high or low. That's exactly what happened in Strack. They didn't adopt a benchmark in that case. Nothing of the sort. They cited a range. They cited this court's range. That's what it is. And in Brown, it goes up to 37%. Now let's go back to your point about who filed those declarations. It's correct, but also not correct, because we submitted evidence to the court of post-Strack decisions. They're in our briefs here. They're in the record. One of them is, for example, Judge Heaton.
But Judge Heaton was applying a stipulation that applied federal common law, not Oklahoma law.
But he looked at what has been happening since. It's absolutely what he did. And you can look at, we've put them in the record. A lot of those are our cases. There is discretion and a range. We're really quibbling over 1.5% here with a judge who has had this case for over 10 years. This court's precedent says we don't go hunting for error, that we give discretion to a judge who has been in a case. Y'all's opinion in Syngenta is one example of that. Judge Holmes wrote, I think, that opinion. This judge knows this case. And let's go back and talk about the record that was before him. Those lawyers and judges didn't just look at a percentage, Your Honor. That's not what they did. They looked at the time records. They looked at the lodestar. They looked at the result achieved. They looked at similar awards in other cases. That's the one you just asked about. But there's 13 factors. And that wasn't just some light group of experts. That was Michael Burge. I think many of you know him. That was Pat Ryan, my co-counsel in Sunoco, who just passed away.
Well, we may think that there are, the most brilliant individuals on the planet, but I don't know that we can, affirm based on the fact that we have high regard, for the credibility of the experts. The problem, I think, is that they're relying on language without analyses were without knowledge that 3 years later that Justice Winchester would allow only a limited exception when the deviations from that range are when the fund is extraordinarily large or small relative to the hours of work expended by the attorneys. So maybe Justice Winchester was wrong, but I don't know how we can just ignore that, based on our high regard for the credibility of your experts.
Well, Your Honor, I'm not asking you to ignore it. I'm asking you to do what Strack says. This court said we had to follow Oklahoma Supreme Court law, and Oklahoma Supreme Court says that judges have discretion and that you have to look at the unique facts before the court. Strack was a case where certification was denied. Strack was a case where they did not get 100% of damages. And one thing, if you look at that opinion carefully, which is clearly you have, there was another $3 million that they were going to get there on top of what was at issue in the $19 million fee award. I know those lawyers very well. I know exactly what happened there because, again, we analyzed it and filed the amicus briefs in that case. It's not the same case. We got 100% here. And if you're going to do a lodestar cross-check, which is what they're saying is required, then let's do the lodestar cross-check. But let's also do it as Judge DeGiusti did twice. He did it 2 times, one on the percentage and one on the fee amount. And
what's your response to the claim that you failed to provide lodestar data early on, which dragged out Chieftain 1 and really created maybe an unnecessary appeal?
Well, Your Honor, I have several responses to it. One, there was a strategic reason, and 2, the objectors have misled this court all along. They're still doing it. I was the one they were pointing to there. I never said, and we've given you the full record, I never said that we didn't have time records. I said that I personally didn't keep them. I'm one of many here. We did, and I said we do have time records, and you have those time records before you. The issue of whether they were submitted was very simple. At the time, there was no Oklahoma court that said you had to do a lodestar. If you look at Strack, I think we should do one, but the law is should, not must. That's what it says. We were following Oklahoma state court and federal jurisprudence and relying on prior authority here. But there was also a strategic reason, Your Honor. And Judge DeGiusti pointed to this. We had a case that originally this case was SM. Intervest bought some of the wells. We were in hot litigation against SM. we did not want to submit time records that our adversaries in that case could see and gain an advantage of. And that carried forward even after we went back and put our time records in, which is why there was redactions and we were originally allowed to put them under seal. But we produced time records, and I think it's critically important, going back to Judge Backert's comments about who these judges were and whether you respect them or not. Judge Van Dyke tried more Oklahoma oil and gas cases than any other judge as a state court judge. Judge Hetherington tried our opioid case. He tried the tobacco case. These are judges that practice in Oklahoma, both as lawyers and as judges, and they know the fee law there. And they know the unique circumstances of our case and our work in these cases. And I think Judge DeGiusti was entirely allowed to rely upon these experts. And I should mention that none of their factual findings were challenged. They objected to using certain experts, Justice Watt and Glenn Coffey, who wrote 2023. But Judge DeGiusti struck those. Everyone else, he said, look, this goes to the weight of my analysis. And Your Honors, it was in his discretion to rely on that.
Well, before you sit down,
Sure.
I also was concerned. The appeal to the United States Supreme Court looks pretty dubious to me. I'm not, and I guess the fee award would include the costs of that issue to the Supreme Court. No, you're shaking your head.
Yes, sir. May I continue? I see my time's out.
Yeah, go ahead and answer my question.
Yes, it's very clear in Judge DeGiusti's order and in our declaration that none of that time was submitted seeking cert. None of it, right? What we submitted was through the rehearing en banc, and I think we were preparing cert at the time that we submitted our fee declarations. So that's not included in there.
But the en banc petition in the 10th Circuit would be?
Yes, Your Honor, and let's go back to that. They attacked the settlement, and when the 10th Circuit issued Chieftain 1, it did not affirm the settlement. And part of our effort in rehearing en banc was to get that clarified. The court did not grant rehearing, but at sua sponte issued a nunc pro tunc, I guess is what it was called, to clarify that the settlement was indeed affirmed. That's critical, if I may just continue, because Intervest went to bankruptcy. And had that order not have been won by us against their attack, this class would have gotten nothing. We would have gone into an adversarial proceeding. Let me just check what I said to make sure I said it right.
Yeah, go ahead and do that and then wrap up.
Okay, that's correct. The time that we spent drafting the cert petition was included, but we also put in there several hundred hours about what would happen if cert was granted. That was not included. We just showed it, but Judge DeGiusti made clear he didn't consider it, nor did we request it. So I want to make sure I got that exactly right.
All right.
Thank you.
Thank you, Mr. Beckberg. We can hear either Mr. Isaacson or Mr. Pence. You have some rebuttal.
So getting it exactly right, he concedes that time put into the cert petition was in fact included in the lodestar. I think that you have focused on whether the 1.5 is a hard cap. I mean, it's pretty firm. I think it's supposed to be pretty firm. And whether it can change over time, I think you would want to look at reported Oklahoma decisions, not unreported district court opinions that are applying a federal common law. The original decision in this case from the 10th Circuit rejected the idea that a federal common law of controls here. It said apply Oklahoma law, and Oklahoma law is what Strack says. Now, Strack has been applied in one published Oklahoma decision called Folsom, where the court said the results achieved were extraordinary, and it reduced the fee award from a multiplier of 3 to a multiplier of 1.3. That's well under the 1.5. Now, a multiplier of 1.5 in this case would generate a fee award of $12 million, not $17.3 million. A 25% fee award in this case would generate a fee of 13 million, not 17.5 million, 0.3 million. 17.3 million was way too much. And we want to go back and look at the reconstructed time records. I think Mr. Beckworth did say that they didn't keep time records. And it turns out that what was put in for many of the time records were daily time slips with the name of the case having Enervest. The case was filed in 2011 in Oklahoma State Court and removed to federal court. Enervest was not added until September of 2024 on the eve of settlement. So those time slips were all bogus. They're all reconstructed after the fact on the daily basis with the wrong case name on them.
Did you raise that in the district court?
Yes, we raised that argument in the district court. We filed a motion, Nutley filed a motion to strike the time records, and the judge rejected the motion. He denied the motion. And given the abuse of discretion standard, that didn't seem like the strongest point to be making on appeal, to take an appeal from striking those time records. But the fact of the matter is that Mr. Beckworth and his colleagues did not keep time records for the most part. The time records were reconstructed, and that is absolutely clear from the record.
Your time's over. Go ahead and finish up.
Yeah, I'd like to finish up. I apologize to Mr. Pence if I've taken his rebuttal time.
All right. Well, I think you did. But Mr. Pence, I'll give you 60 seconds if you want.
Thank you, Your Honor. I appreciate that. I believe I heard Mr. Beckworth say that in 2015, there was no Oklahoma court, this is an exact quote, that said you had to do lodestar. I mean, even Judge DeGiusti said in his opinion that if we need to follow Oklahoma law, we don't have enough information to make a fee award right now. I don't know how Mr. Beckworth could possibly say that. It was clearly required then. His argument then was we don't have to follow Oklahoma law. We can follow this federal common law that he apparently still believes in, but he believes that that what constitutes federal common law are these unreported decisions where you basically stipulate around the law of Oklahoma and they never see the light of day. But the law that governed was the law announced in Burke and then confirmed in Strack, which is you have to produce your lodestar, which is why the class counsel invited the error that required and led to Chieftain 1, and they shouldn't be able to charge the class for that.
All right. Thank you, counsel. I think we understand and appreciate your arguments. Counsel are excused and the case will be submitted. This panel will be adjourned and will reconvene in about 60 to 120 seconds. Thank you.
Thank you.
Judges, everyone is in the waiting room, so no one can hear you. I have brought Judge Hartz into the meeting.
Here I am.
Hi, Judge.
Hey, Harris.
Hi, Bob.
The Honorable Judges of the United States Court of Appeals for the 10th Circuit.
Thank you. Oh, I didn't see Mr. Brown, but wait, where is he? Thought I saw him for a second.
Can you see me?
Oh, yes, you're in the middle. Yes, I was looking on the top. Okay, good. Okay, we have 5 more oral arguments scheduled for this morning, and we'll take a break probably after the third of the remaining 5, maybe earlier, take a 10-minute break. But otherwise, we're ready to start in 23-3175, U.S. versus Otuonye. I'll ask counsel to pronounce that for me. So, Mr. Brindley, are you ready to proceed?
I am, Your Honor.
Go ahead.
My name is Bo Brindley, and I represent the defendant appellant Ebube Otuonye. In Henson 2 and Con 2, this court clearly enunciated the state of the law in the 10th Circuit following the Supreme Court's decision in Ruan versus United States. All money laundering convictions for Dr. Khan and Dr. Henson were reversed despite being individually and legally accurate, because in order to make a determination on the guilt for those counts, it was necessary to refer to the instruction regarding the 841 counts and the definition of an illegal prescription.
Well, that's because the money laundering charge required that they actually have committed those offenses, right?
Indeed.
Yes.
Here, the healthcare fraud counts in this case are directly analogous. And the reason is because the only basis for healthcare fraud that was in the indictment, or that was argued to the jury, or that was even possible, was if there was the filling of an illegal prescription. And the only way to determine the legality was to go back to instruction number 16, which incorrectly defined what an illegal prescription was.
Well, it's a little different. There's a difference between an illegal prescription and violating the law regarding unlawful prescriptions by doing it knowingly or intentionally. And that wasn't an issue with the money laundering case, because the way RICO, or the money laundering statute, refers to the underlying offense is there has to be a commission of the offense. So the scienter requirement was already there. Here, I'm not sure why that's necessary. Why? Go ahead.
There would be, I'm sorry, Your Honor, there would be no way for the jury to make an assessment of whether the defendant in this case was guilty of the healthcare fraud counts without looking at instruction 16 to determine whether the prescriptions were legal or not, because the only basis for saying Mr. Otuonye committed a crime with respect to Medicare and Medicaid fraud was if he filled prescriptions that he knew to be illegal. But the definition for what it means for them to be illegal harkens back to instruction 16, in which is analogous to the situation that we're dealing with respect to the money laundering counts in Con 2 and Henson 2, and the conspiracy charges as well.
Except that the defect, I want to get to the defect in instruction 16 at some point, but the defect that you're alleging here is it didn't include the necessary scienter requirement.
Yes.
But the fraud, the Medicare fraud count, did have a scienter requirement.
It does.
Why doesn't that take care of any problem with the scienter with respect to the distribution count?
Because it says knowingly committed the offense, essentially, but the problem is knowingly did what? The question is, what did he knowingly do? And the only thing that he knowingly would have done is filled a prescription that was illegal. But to figure out whether it's illegal, the jury has to look back to instruction 16 and determine, well, were these illegal or not? And they had they couldn't get a right answer on that based on instruction 16. The knowingly part of the healthcare fraud.
If 16 says it's illegal to do something without scienter, and that's what illegal filling prescription is, and that's the basis of the fraud.
Mm-hmm.
But the instruction on fraud requires scienter.
But scienter of knowledge of what, Your Honor? That's the problem. It's knowledge of what?
Knowledge. Well, let's look at instruction 16. For example, knowledge that it was filled outside the usual course of professional practice.
Yes.
You agree that needed to be shown. That was an alternative under instruction 16.
That's what the Supreme Court says, that has to be shown, that he knew it was outside the course. Dr. Henson knew it was
convicted of distribution. But you're saying, what did he have to know to be guilty of Medicare fraud? And he needed to know that it was filled outside the usual course of professional practice.
That's not what the Medicare fraud instruction said.
Well, let me ask you about that, okay. About, and I don't mean to talk over your answer to Judge Hart's, but when you talk about instruction 18, which I assume you're getting to, yes, the instruction on the elements, Judge Hart's has asked good questions about the first element. What about the fourth one? The defendant acted with specific intent to defraud. How can you possibly combine the jury's consideration of instructions 16 and 18 without the jury clearly understanding that that the pharmacist had to have acted with intent to defraud in order to be guilty of counts 3 and 4?
Intent, but the problem is that with respect to intent to defraud in what way is the question. And the only way that's been issue in the case was by filling a prescription that was illegally written. And the jury would look at whether it was illegally written or not in order to make that determination. I don't think there's any way that we can say with confidence that the jury could just look at 18 and not go back to 16. And if they did go back to 16, that they somehow could combine them in the way that we're talking about combining them now. I don't think there's any way to say with any degree of confidence that a jury is going to be able to do that. And I think this is similar in the Fourth Circuit. There is a case called United States versus Smithers that had a similar argument with respect to an instruction about keeping a stash house. This was a doctor, an opiate doctor too, and they reversed all of the counts in Smithers, and this is in the Fourth Circuit. And in U.S. versus Smithers, there was a scienter requirement for the keeping of the stash house, and the Fourth Circuit said that still doesn't matter because it's ultimately going to require the jury to look back at the definition of what makes the prescription illegal. And if they're misled about that, there's no way that we can know with any confidence that they're going to get this right.
I wonder if we're talking about... Oh, you go ahead.
No, you go ahead.
I was just...
Go ahead.
Okay, I'm sorry, Judge. I wonder if there's maybe a generality in the terminology that we're using. When you say that it was illegally written,
yes.
Now, I think when you're saying that you're referring to the controlled substances, yes. But in closing argument, and the prosecutor did say that, I don't know if Mr. Brown or someone else in his office, when there was a change of plea hearing, but of course the district judge didn't accept the plea, and so it goes to trial, and in closing argument, the prosecutor specifically says, as Mr. Brown quoted in his brief, that it doesn't have to be the controlled substance. In other words, if the ploy, as it was identified in the indictment, was to conceal this scheme that the pharmacist had, that he was not turning in to Medicare and Medicaid the costs for the controlled substances, but he was having Dr. Henson call in these unnecessary expenses. Now, I don't know that you would say those are illegally written. They're certainly illegal to submit because they did not have a legitimate medical purpose. And that was the $17,000, all of which, as I understand it, was not for reimbursement under Medicare and Medicaid for controlled substances. They were all for the non-controlled.
Two things on that. Number one, the district court had a conversation with Mona First trial counsel, which we cited in our brief, about the question of whether or not this was referring to the Medicaid frauds, referring to the non-controlled substances.
That was at the change of plea hearing, right?
Yes, and she said it was the controlled substances that they had been talking about. The indictment also references the controlled substances only. It doesn't talk about the non-controlled substances. But anyway, regardless of which way you go, if you're trying to decide whether or not the prescription of the non-controlled substances was within the usual course of professional practice, then the jury is likely to look back to instruction 16, even if they're talking about non-controlled substances. The fact that there is this instruction that talks about what it requires in order to have a prescription written that is in line with the law, which instruction 16 does. It has to be in the usual course of professional practice. It has to be for legitimate medical purpose. The idea that the jury's not going to confuse that, or the assumption that they're not going to confuse that in this set of circumstances, is hard to believe when the totality of the argument of this case and the presentation of this case was that the prescriptions for controlled substances were, and I say illegally written, were written outside the usual course of professional practice, and the pharmacist filled them. And so that means that he's guilty. And
was any of the $17,000 that the prosecutor relied on at trial, was any of that for reimbursement for the controlled?
The $17,000 that was discussed at the trial, is that what you're asking me about?
Right.
I honestly don't know the answer to that question. Maybe Mr. Brown does, Your Honor. I don't know the answer to that
question. Well, Mr. Brown, I think, has already said it in his brief. And he said it was all for the non-controlled substances.
But even if it is, the problem is making a determination that the jury was not going to be impacted and the decision was not going to be impacted. And if the decision was impacted about all of the controlled substance prescription, and the jury easily, there's two theories that we're suggesting. Maybe they decided on non-controlled, maybe they decided on controlled. There's no way for us to determine which one they decided on. And if they decided on
prejudice under prong 2 of Strickland.
We show prejudice by showing that the jury was not, there's two possible theories. One of those theories would require the jury to go back to an instruction that included an omitted element. And as this court said in Hansen 2 and Kahn 2, an omitted element of that kind, the only way that you could find that there wasn't prejudice would be if you could find beyond a reasonable doubt that it was basically an uncontested or uncontestable issue. And the government has an argument with uncontested in this case.
Yeah. I mentioned I'd get to this later and we're almost out of time, so I want to raise this issue. You say that instruction 16 was incorrect because it omitted an essential element. Is that correct?
I do.
That's the only thing wrong with it, essentially. That's the only thing you've raised about.
That's correct.
And what is the element that's missing?
Knowledge and intent.
Knowledge of what?
Knowledge that the prescription is outside the usual course of professional practice. Knowledge that the prescription is without a legitimate medical purpose.
Okay, so would you look at instruction 16 and look at the sentence? Because it does require knowledge. It says, in other words, if the government proves beyond a reasonable doubt that a prescription was knowingly dispensed or distributed, number 1 in parentheses, not for a legitimate medical purpose, or 2 in parentheses, outside the usual course of professional practice, then the exception to the Controlled Substance Act does not apply. It clearly requires knowingly outside the usual course of professional practice.
That is
the cases you relied on do not have number 1 and number 2 in the sentence. And that's why it was ambiguous whether the second part of the sentence, outside the usual course of professional practice, was modified by knowingly.
The instruction in the Kahn case is almost identical.
Yeah, except it deletes number 1 and number 2. Which eliminates the ambiguity, does it not?
No, I don't think it eliminates the ambiguity.
You can read, let me ask. So you read, I just want to make sure I understand your position. You're saying when it says was knowingly dispensed or distributed, number 1 in parentheses, not for a legitimate medical purpose, comma, or numeral 2 in parentheses, outside the usual course of professional practice, then the language knowingly dispensed, knowingly, does not modify what's after number 2?
I think knowingly can just apply to the distribution. And there's been lots of argument in the case law about this. Knowingly distributed, yeah, he knows that he distributed it. But the question is then, does knowingly also follow through to number 1 and number 2?
Right. And if it's before number 1 and number 2, that makes it very clear that it applies. When you say he must intend to do number 1 or number 2, then it clearly requires knowingly for both purposes. What was missing in the precedent you're relying on is the numeral 1 and numeral 2.
No.
Which eliminates ambiguity. No. You disagree?
Yes, because in the Khan case, they said that it requires more than just that knowledge. In Khan, the 10th Circuit said that what is required is knowledge that it is illegal. If you go back and look at Khan says that the defendant must know that the prescription is written outside the usual course of professional practice and must know that doing so was illegal. So it's a higher degree of scienter than just the knowledge that's written in Instruction 16 if we take the Khan case for what it says.
Okay, so you're saying that the scienter required in Khan is not just knowing that it's outside the usual course of professional practice, but knowing that distributing or dispensing outside the usual course of professional practice is unlawful. You're saying Khan requires that also?
Yes, because a doctor could know, if I could finish just this question.
Yes, please.
Because if a doctor can know that he's writing a prescription that's outside of the usual course, but believe he still has the authority to do that under the Controlled Substances Act. In order to be guilty, according to Khan 2, he has to know that he doesn't have the authority. Khan 2 is not about knowledge of those two prongs. It's about knowledge that he was unauthorized. And that's what's completely missing. Knowledge of unauthorization is what's going on in Khan 2, and that is nowhere to be found in Instruction 16. And there's no way the jury could figure that out when assessing these healthcare fraud counts. Knowledge of unauthorization is different from knowledge of being outside the course.
Okay. I think I understand your point there.
Thank you. And with that, I've exhausted my time.
Thank you, counsel. Mr. Brown?
Can the panel hear me?
Yes.
Okay. Good morning, Your Honors. James Brown for the United States. I'd like to start with an issue that the panel did not touch on during my colleague's presentation, which is the issue of the waiver of the claim that we're now considering whether or not his initial 2255 claim even brought up any challenge to counts 3 and 4. We've argued that it did not. He presented that claim in an untimely manner. His claim of ineffective assistance related exclusively to instruction number 16, and instruction number 16 was relevant only to counts 1 and 2. It was not relevant in any way, shape, or form to counts 3 and 4. And in fact, the district court gave an instruction telling the jury in instruction number 5 that what they decided on one count did not require them to make a decision on another count. That's instruction 5. We think instruction 5 basically told the jury that counts 3 and 4 were not parasitic on counts 1 and 2. There's no other way to read instruction 5. He didn't object to instruction 5 below at any point, and he didn't object on appeal. He doesn't object now. That's a correct statement of the law. And it basically says that counts 3 and 4 are not parasitic on counts 1 and 2. That basically binds his whole argument.
Well, the judge also instructed the jury on paragraph 48 of the indictment that alleges a scheme to control healthcare fraud, quote, by distributing and dispensing controlled substances illegally. That, even crediting your point about instruction 5 about the difference in the counts, paragraph 48 of the indictment, according to Appellant's counsel, does make counts 3 and 4 parasitic on counts 1 and 2 explicitly. What's wrong with that argument?
Well, first of all, that argument is outside the scope of the certificate of appealability. That's basically a variance argument that he should have raised on direct appeal to challenge counts 3 and 4. He did not. He raises that the first time in his brief here. He didn't raise it below at any point. That's basically sort of a perfunctory argument raised now. What we have up to this point was we have instruction 5, which says counts 3 and 4 are not parasitic on counts 1 and 2. And then what's wrong with that argument, if you want to get past the fact that it's not even cognizable in this proceeding, is the fact that in order to determine whether somebody is guilty, you look at the instructions given to the jury and the elements in those instructions to consider the guilt. Here, he didn't object to the instructions in counts 3 and 4. Counts 3 and 4 allowed the jury to determine whether or not he engaged in a scheme to defraud and had specific intent to defraud. The jury could have looked at, as the court pointed out in my colleague's presentation, the non-controlled substances for that, which had nothing to do with violations of the Controlled Substances Act.
Can I test that a little bit, Mr. Brown? So let's say I'm a jury and I hear Judge Belgren instruct on, read aloud in paragraph 48, read aloud instruction 5, 16, and 18. And I, as a jury, am thinking, why would it be unreasonable for me as a juror to think, okay, well, we do consider the counts separately, but when I decide whether or not the pharmacist it defrauded Medicare and Medicaid, I am looking at whether or not he distributed and dispensed controlled substances illegally. That's the illegal distribution. So his argument that counts 3 and 4 are parasitic seems credible, irrespective of your argument about considering the counts separately. Yes, you consider the counts separately, like in any case, but in this particular case, the judge seemed to explicitly make 3 and 4 parasitic on 1 and 2. What's wrong with that?
Well, the jurors were not allowed to disregard instruction number 5 under any circumstance.
Or paragraph, or the instruction reading aloud 48.
Well, that was basically sort of background given in the indictment, but the jurors weren't allowed to disregard the instructions, and the instructions didn't require that. But also keep in mind, again, this is a variance argument that should have been raised on direct appeal.
I think that's where I maybe ask my question inartfully. I'm not talking about a variance argument. The whole theory of the ineffective assistance based on prong 2 of Strickland that the appellant is making is that counts 3 and 4 are parasitic on counts 1 and 2. That's the theme of the appellant's counsel, as I understand it, maybe wrongly. And so I don't care. I don't think Mr. Ridley cares of whether or not there was a variance from the indictment, but we're all talking about instructions and how the jury is going to process those instructions. That's what I'm trying to get at.
Right. And my response is the jury was not allowed to ignore instruction number 5, which told them that counts 3 and 4 were not parasitic on counts 1 and 2. They were not allowed to ignore that instruction. So they may have considered that as background information, but that doesn't mean they were allowed to ignore instruction number 5, and they weren't allowed to ignore it. And,
how do we get around Kahn then?
Kahn, Your Honor, in my colleague's presentation, I think pointed out, or was it Judge Hart's, pointed out how we get around Kahn and Henson. It's very easy. In Henson, the money laundering counts were parasitic as a matter of law on the drug counts, because the money laundering proceeds had to come from a specified unlawful activity, and the specified unlawful activity was the conspiracy charge, the conspiracy drug charge. That's parasitic as a matter of law. He's claiming parasiticness based on basically evidentiary overlap, and that is not controlling as to whether a count is parasitic. You look at an elements-based test, which is basically what Henson did. Those were the money laundering counts were parasitic as a matter of law, as the panel has already pointed out. Here they were not.
So you think Kahn was correctly decided then?
We think Kahn was correctly decided, but if you go to pages 1321 and 1322 of Kahn, The court finds that the counts that were related to the conspiracy conviction that was overturned were basically parasitic on that conspiracy conviction as a matter of law. The 924C, the money laundering. A money laundering requires a specified unlawful activity as an element of the offense. The specified unlawful activity was conspiracy to distribute the drugs. That's parasitic as a matter of law. And it went the same way for some other counts in Con 2. So that doesn't really help him. It doesn't get him anywhere for this argument. But let me finish up, if I may, on the waiver, and then I'll move to the merits. Basically, the question in here is whether the district court abused its discretion in denying defendants' claim as to counts 3 and 4. And we have argued that the defendant waived that claim, and that claim is also successive under this court's law. And the district court cannot abuse its discretion by failing to consider a waived claim or a successive claim that it does not even have jurisdiction to consider. Therefore, there's no abuse of discretion. The court found that it was untimely presented. The court said that would be a sufficient basis by itself to not consider the claim, but the court went on to address the merits. There's no abuse of discretion in not considering a successive claim that the court did not even have jurisdiction to adjudicate. Now,
in making that argument, Mr. Brown, or making that rationale, did Judge Milgren commit a factual error in the denying the motion to reconsider? He said that the appellant the defendant had not made that argument until the motion to reconsider. I think we all agree, and you've acknowledged in your briefing, that he did include that in his reply brief before the motion to reconsider. And, maybe Judge Milgren would have said it was too late to submit that in the reply brief, but that's not what he said. He said that he didn't submit that argument at all until the motion to reconsider. That's two different things, and that's actually inaccurate, isn't it?
Well, okay, what I'm relying on is Supplemental Volume 2, page 83 and 84. And I'm sorry, Supplemental Volume 2, page 85 and 86. So if any fact inaccuracy should be judged against those pages. What I'm trying to use those pages is to show the proposition that he did not put on any evidence or argument as to counts 3 and 4. And at the evidentiary hearing, he says, this alone is enough to deny defendant's motion, as a motion for reconsideration is an improper place to assert arguments for the first time.
And that's wrong. He submitted it before the motion to reconsider. He submitted it in the reply brief.
Well, okay, then I see what the court is saying. I wasn't understanding what the court was saying. I see what the court is saying. Okay. Anyway, it still doesn't take away from my main point. The claim was untimely presented, and the court did not abuse its discretion in rejecting it on that basis. The reply brief was too late to bring it anyway. The reply brief was several months late. The reply was filed on March 17, 2023, his initial claim was brought on August 2, 2022. That's when he was required to bring it. So it was still too late, even if it was raised in the reply brief. The factual inaccuracy of the district court is irrelevant here. So, no abuse of discretion in denying a claim that is out of time, waived, and successive. That's the major point. But let me move to the merits. First of all, I think we've shown how his reliance on Henson and Kahn is completely inapt. Those cases had the money laundering counts were parasitic as a matter of law. Here, the healthcare fraud counts were not parasitic as a matter of law. Count 5 instructed that they were not parasitic as a matter of law. The jury was required to obey that instruction. Number 2, there was the elements, as I think Judge Hartz pointed out, in counts 3 and 4 were materially different than the elements of counts 1 and 2. The jury had the opportunity to judge the evidence in accordance with the jury instruction on instruction 18, to which defendant did not object below or now at any time. And the jury considered the evidence and found that he basically devised a scheme to defraud and had the specific intent to defraud because he filled prescriptions that were illegitimate. There was substantial testimony to show that the prescriptions were illegitimate. Corby Harshaw, whose testimony I think we put on page 54 in our brief, talked about how the prescriptions were medically unnecessary and therefore illegitimate. We showed his intent, and he even during his evidentiary presentation at trial, or at least in closing argument, admitted that Henson made illegitimate prescriptions. He didn't contest Henson's scienter at any time, and that was sort of part of his argument, that he was tricked by Henson, who was devious. That was his defense. Ignatiak. The defendant relies on the Ignatiak case, stating that Ignatiak controls this. It does not control that. Ignatiak is a 2012 case. The Rowan issue was not even there. Ignatiak does not have this competition between the Rowan instruction and a healthcare fraud instruction, and comparing the elements and comparing the evidence and seeing how the evidence fits within those elements, those two different things, for purposes of deciding whether there was any Rowan error. The issue in Ignatiak was whether a confrontation clause violation affected all counts. That's not what we have here. And to the extent that Ignatiak talks about evidence relating to the drug counts, here we don't have a pure Controlled Substances Act scheme to defraud, because our scheme to defraud for the healthcare fraud counts on 3 and 4 involves non-controlled substances, as we point out in our brief and as we argued at trial. So basically, the Controlled Substances Act doesn't even affect Mr. Otuonye's dispensing of the non-controlled substances as part of a scheme to defraud. I think that really covers most of what I want to say. I'll take any questions at this point if the court has any.
Well, thank you, Mr. Brown. I don't have a question. It doesn't look like any of us have a question at this point.
Okay, thank you.
So case is submitted. Counselor excused. Thank you, gentlemen. We can turn to our next case. Looks like we're all here. We'll turn now to 24-4114 Dressen versus AstraZeneca AB. Mr. Anderson, are you ready to proceed?
I am, Your Honor. Good morning, and may it please the court. I'm going to try to reserve 3 minutes of my time. In a declared national emergency like the COVID pandemic, federal immunity for vaccine manufacturers depends on 2 things. 1, does the plaintiff assert a loss covered by the statute? And 2, was that loss allegedly caused by the administration of a vaccine? The complaint answers both questions for us. Ms. Dressen says in paragraph 27 that she suffered, quote, a COVID vaccine injury. In paragraphs 168, 169, and 174, she seeks to recover her medical expenses and emotional damages. That's her loss. That she says she, quote, incurred as a result of the vaccine. That's the causation. The PrEP Act directly addresses this scenario. It gives manufacturers immunity from suit and liability under federal and state law for all claims for loss, which Congress broadly defined to include the physical, mental, and emotional injuries that Ms. Dressen claims here, anytime that loss has a causal relationship to the administration of a vaccine. The plain text bars this suit. The decision below should be reversed because nothing in the statute carves out contract claims.
Why did your client bother entering into these contracts in the first place if you're going to, fail to honor them and claim immunity? I don't quite get it. Is that because the PrEP immunity came later?
So, Your Honor, this is AstraZeneca's global standard informed consent form, and it's attached to the complaint. And you see that this is a required element of clinical vaccine trials all over the world. And in this case, the PrEP Act immunity, Congress just overlaid the conditions for enforcement of any kind of claim. So all claims for loss. but every single promise that was made in the informed consent form was made subject to the PrEP Act. That's the choice that Congress made. And Ms. Dressen was directly informed expressly that the PrEP Act may limit her ability to sue or recover. And this was not some fine print on page 62 of the appendix here. There were 3 paragraphs that spelled out the limitations that federal law imposes under the conditions of a national emergency right here. And so the analytical error below is when Congress said all claims for loss, they used that phrase because they meant all claims, right? So we need to have a loss in causation. And under those circumstances, Congress was agnostic to the legal theory that was applied.
Well, is her argument that the PrEP Act compensation does not fully compensate her for the vaccine injury? Is that the underlying controversy between your client and her?
I think the underlying controversy here is again a statutory question of whether contract claims are categorically excluded. Now, obviously,
I'm talking about what the damages theory is.
Correct. And so the damages, we understand that Ms. Dressen has sought compensation from the exclusive remedial regime that Congress created, the CICP, and that the losses that she sought from the federal compensation program are the exact same losses that she seeks here. And she's entitled to seek compensation through the federal program, but what she can't do, because the statute forbids it, is pursue duplicative state law claims for what she attributes to the COVID vaccine, right? That's precisely the sort of claim that the PrEP Act immunizes.
Now, could your form, are you saying that the protection provided to AstraZeneca by the Act cannot be waived? Could it be waived in a form?
Now, presumably a clear and unmistakable waiver of immunity, I don't think there's a reason that it couldn't be. We certainly don't have that here. We have the opposite.
Well, that has not been litigated, right?
Correct, Your Honor.
So we could decide that this is a claim that is covered by the Act and remand to the district court to see whether there's been a waiver. Could we not?
Correct, Your Honor. That was an alternative theory that was raised below. It's an alternative theory for affirmance raised on appeal. It was not decided below. And I would respectfully submit that the clear and unmistakable standard for waiver can't be met in a circumstance where the immunity itself was clearly disclosed on the same page of that informed consent form. But yes, Your Honor, that could be decided below.
So we don't need to decide whether the form overrides the Act. We don't need to decide that at this stage of the proceedings.
No, Your Honor.
The question just is whether the damages she's seeking are covered by the PrEP Act absent a waiver. Is that right?
Correct. Whether the statute carves out contract claims. And that is the question on interlocutory appeal here. And
Mr. Anderson, I do have a question about that. Are you finished answering Judge Hart's? I do have a question about the collateral order doctrine applied here. And, our cases are pretty stringent on the application of that. In particular, when you're looking at litigation between two private parties, we almost never agree that those types of disputes, even with an underlying immunity, can be interlocutorily appealed. What do you think makes this one special?
It's Congress's choice of the scope of immunity here. It's immunity from suit and liability. That's the statutory text. And so as every court of appeals to have addressed this question has agreed, that is subject to interlocutory appeal from a denial of a motion to dismiss. So the Sixth Circuit in Goins, the Eighth Circuit as well, recognizes that meets the Cohen or Mohawk standards for an interlocutory appeal for sovereign immunity or for immunity here. And they're applying familiar doctrines of sovereign immunity, tribal immunity, qualified immunity that make this an appealable final order, because the immunity from suit would be forever lost if this case proceeds beyond a motion to dismiss.
Well, it'd be lost in this case, but the issue could be resolved on a direct appeal. I don't necessarily disagree with you. I've been on the losing end of these collateral order in the 10th Circuit, so I have a lot of sympathy for that. But having been on the losing end, we've found no collateral order for litigation privilege, for Bivens actions, False Claims Act. We have for, the case, you cited cases in your brief, and so we've gone kind of both ways. But I think you've answered my question. It's basically Congress has given you a broad immunity, and you deserve to have that decided.
That's right, Your Honor. And so turning back to the merits, because the question on appeal, again, to Judge Hartz, is this narrow question of whether the statute carves out contract claims categorically. And we know it doesn't. In fact, Congress knew how to create an exception for contract claims. It wrote one in the PLCAA, that's the firearm statute, just 2 months earlier. And it omitted contract claims from the sale or purchase of a product. But it omitted that carve out in the PrEP Act. And that omission was deliberate because legislators were forced to make the difficult policy choice that in an emergency, the national interest is best served by the rapid development and deployment of life-saving vaccines without the looming threat of litigation, right? It was balancing the private rights with public safety. But as was alluded to earlier, Congress did not leave participants without a remedy. It centralized that recovery in the CICP. And so, again, Ms. Dressen has sought those claims here. And I want to focus on what I believe to be the key analytical error made in the decision below, because the district court found an exception for contract claims in the causation element. And respectfully, I believe the court misapplied that causation element. The district court asked whether the breach of contract was caused by the administration of a vaccine, rather than asking whether the loss was causally related to the administration of a vaccine, which is what the statutory text requires. So the district court just asked the wrong question and therefore reached the wrong result. Congress was focused on losses, not labels. And if a covered loss is causally related to the administration of the vaccine, then all claims are immunized under the statute. And as this court recognized in Allen, all means all. As the Supreme Court recognized in Norfolk and Western Railway, an exemption from all other law, which was the statutory language in that case, includes contract claims. There are no implicit exceptions in Congress. And that breadth is a feature of this law. It's not a flaw. While the uniform rule may seem broad, it's the very breadth that allows the life-saving countermeasures to exist at all.
Did we lose you?
No, I'm still here. I welcome the court's questions. I'm happy to reserve the remainder of my time.
You didn't move, and I thought maybe there was a transmission problem.
May I ask a brief question? If we do reverse, do we need to go through, in your prayer on page 37, you include a number of things. You alluded to some that fit the PrEP Act's definition or illustrations of what constitutes a loss: emotional injury, medical injury, and the like. But there are some species of recovery, like lost income. If we do reverse, do we need to go item by item in your prayer and determine which of the specific requests for relief in the complaint are or not proper losses that would fall within the immunity under the PrEP Act, or do we just skirt that?
Your Honor, I don't think that level of parsing is necessary. And in fact, that would encourage artful pleading. I think what Congress was focused on is the nature of the loss writ large, not how many different kinds of loss can be articulated. And lost income, for instance, could be captured by the business interruption definition of loss, which of course Congress defined as all kinds of loss, and then included some specific examples. So I don't think that level of parsing is necessary. And what it boils down to, respectfully, is that absent the injection, no claim exists at all in this case. And so that's, again, that was Congress's focus here, looking at the loss, determine whether it meets a relaxed causation standard between the administration of the vaccine, and that is this case, and therefore immunity applies.
Thank you.
If there are no further questions, I'd like to reserve the remainder of my time.
Thank you, counsel.
Thank you.
Mr. Conant?
May it please the court? My name is Michael Conant. and I am an attorney for the appellee Brianne Dressen. At its root, AstraZeneca's position is that it has a license to breach its contracts, a license to break its promises, and more fundamentally, a license to lie. That the immunity under the PrEP Act is so radically broad that it can lie to clinical trial participants like Ms. Dressen without incurring any civil liability. AstraZeneca's position is that it can induce prospective trial participants like Ms. Dressen to take an experimental drug by unequivocally promising that if they get injured, AstraZeneca will cover their costs. And when trusting members of the public act on this promise and get injured, AstraZeneca can simply turn around and say, sorry, we don't owe you a single solitary cent.
Now, how is that argument different from your waiver argument? Is it essentially the same as the waiver argument? Because apparently if there weren't this form, you would say that they're protected, but because of the form, they're not protected, which sounds like a waiver argument to me.
Your Honor, that's a good question. I think ultimately it's two pathways to get to the same result. Either the PrEP Act, as we argue, does not include and does not cover contractual violations at all, or if it does, then AstraZeneca waived that right by knowingly extinguishing a right that it had by making the promise to pay Ms. Dressen's costs if she gets injured. So I think it's two pathways to the same end.
But let me explore your argument for the primary pathway you seem to be taking, which is that the PrEP Act doesn't cover contracts, breach of contract. As I understand it, your argument rests in large part on the list of things that of losses that are not covered under the PrEP Act that there's immunity for, and you have death, physical, mental, or emotional injury, and so on. And you say these are tort losses, and that supports the position that contract losses are not covered. Am I getting that close to right?
That is part of it, Your Honor. It's one piece of the puzzle. We look to the words of the statute to understand what all claims means. And when looking to the words of the statute, we see that it is laced with tort-based language, both in terms of tort-based mental states, willfulness, recklessness, negligence, tort-based damages like death, physical injury, emotional injury, as well as tort-based conduct. If you look at A2B, when we're talking about the scope of immunity, the statute provides a classic laundry list of the type of conduct that you see in product liability tort cases. So our argument is, first, look, you understand what a word means by the company it keeps, Noscitur Associates. And in this statute, it is laced with tort-based language. But that's not all, Your Honor. You look to, because clearly the statute does not speak to contracts one way or the other. You either have to read in contracts or read out. Our position is the far more reasonable construction is to read contracts out. And one of the ways you get there is you look to the history of the act. You look to the purpose underlying the act. And as we note in our papers, the history here is you had a tidal wave of tort claims and tort liability against pharmaceutical companies for vaccines. Congress was very sensitive to that. They wanted to ensure that vaccine companies did not have crippling tort litigation. And so they implemented the PrEP Act to address tort liability. but there was never any such thing as contract liability for pharmaceutical companies with respect to vaccines. There's not a single solitary mention in the congressional record about needing to protect vaccine companies from contracts. So we would argue, Your Honor, that the words of the statute, this tort-based framework, aligns with the history that gave rise to the act, as well as Congress's purpose in enacting the act. And
I didn't mean to interrupt you. I thought you had concluded, but
I would just add one other point, and one other way you get to this result, Your Honor, is, which I think is a very important piece here, is the absurdity doctrine. I think it is unthinkable that Congress could have intended for pharmaceutical companies like AstraZeneca to be able to lie through their teeth to clinical trial participants, promise them that they will cover their costs if they get injured, and then turn around and say, nope, we don't have to pay you because Congress gave us a license to lie. It's absurd and bizarre to think that Congress would have done that.
Doesn't the informed consent form have a disclaimer about potential congressional prep immunity? Why doesn't that put your client on fair notice that there might be an immunity problem down the road?
I don't think it does, Your Honor, for several reasons. First off, the contract is very clear, unequivocally so, that AstraZeneca will pay the costs of a research injury. That language is unequivocal. By contrast, several paragraphs later, there is language that doesn't mention the PrEP Act, never discloses that there is a PrEP Act or how to find it. It talks about a federal order or federal rule, but more importantly, Your Honor, is it never says there's a federal statute that prevents you from ever recovering costs from us unless we commit willful misconduct. Instead, it speaks in very ambiguous and equivocal terms as there is a federal order that may limit your right to sue. May limit. It doesn't say will limit. It doesn't take the position that AstraZeneca takes here, that there's complete immunity and they don't have to pay a cent. It doesn't speak with that.
But they're saying may because this is a global consent form, and sometimes the vaccines or whatever drug they're administering is covered by the PrEP Act, and sometimes it's not. So isn't that what the may is referring to? There may be a statute that limits liability.
I don't think you can consider that, because I think that goes beyond, like, if you look at parole evidence rule, we need to look to the four corners of the page. Whether or not, and there's no evidence in the record to indicate that AstraZeneca, why they drafted the contract that way and whether they have the same language in other countries. I think you need to look at the contract as written between a sophisticated party like AstraZeneca and an unsophisticated trial participant and ask, what does the plain meaning of that contract state? What does the plain meaning say? It says clearly and unequivocally, we will pay your costs. And then later it says there may be a federal statute that may limit your right to sue. How does an ordinary lay person interpret that? They look at it and they see a clear promise to get their costs recovered if they should get injured. And the other stuff is kind of, what does it mean? I don't know. I mean, what does that language even mean?
I think we get your point there. Let me ask you, though, what were you seeking to recover in your lawsuit?
We are seeking, Your Honor, to cover the full extent of damages that can be recovered under the law of contracts, both general damages.
Well, I want to know specifically, because I gather from what opposing counsel recited a few minutes ago from the complaint, you want the pay for her medical expenses and recovery, emotional losses and so on, things that are listed as losses under the PrEP Act. So why does that language if what you're seeking through a contract claim are losses that are specifically listed in the PrEP Act, how can you say that the fact that that language is used in the PrEP Act shows it's limited to tort claims and not contract claims?
So I'll start by saying that the damages that we seek in this case do happen to be partially coextensive with the damages that you see in tort cases. And
what's the difference? What you say partially coextensive? Can you name something that wouldn't be covered in the tort claim?
Yes, Your Honor, I think that you'll see a difference in what you can recover for emotional damages in a contract action. There are more limitations on what you can recover, as well as different hurdles that you have to overcome to recover emotional damages under controlling Utah precedent, which we have briefed below. Okay. And also there's limitations on things like punitive damages. So
how can you have a breach of contract here without a vaccine injury?
Your Honor, you can't. And the reason you can't is that AstraZeneca drafted this contract. And when they drafted this contract, they made the condition precedent of their obligation to pay a vaccine injury. So our claim follows the terms of their contract. Their contract says if the condition precedent, namely vaccine injury, occurs, we will pay the costs. So our claim seeks to recover the general damages of the breach. The general damages of the breach follows the promise. The promise
but the condition precedent isn't satisfied without the vaccine causing a vaccine injury.
Correct. And so, but this goes to the
right. So there's no breach if there's no contract injury.
There's no breach without a vaccine injury, correct, Your Honor. And our position, our argument is that, when we look to the scope of immunity under a statute, we look to its purpose. The purpose of the PrEP Act, as the both parties agree, is to promote the rapid development of countermeasures, including vaccines. A critical component of that are clinical trials. And clinical trials require public participation, which requires public trust. And if you allow pharmaceutical companies to straight up lie to trial participants by saying, we're going to cover your costs if you get injured, and then turn around and say, sorry, we don't have to pay you, and we're not going to pay you, that will erode, perhaps irreparably so, the trust that is essential to public participation in clinical trials. So
go ahead. You go ahead.
Go ahead, Judge Bacharach. No, let's move on. I think we understand the point being made, so go ahead, Judge Bacharach.
My question to you, Mr. Conant, is I understand that none of us had a role in writing the PrEP Act. The first thing that you said, I want to push back on that we start with the purpose. I don't think that's true. We start with the words of the statute. And I think that, and you can tell me if I misunderstood your last answer to Judge Timkovich's question, but at least in paragraph 37 of the complaint, you have included medical expenses, emotional injury, illustrations, as Judge Hart's mentioned, that are examples explicitly of losses that are enumerated in the PrEP Act. So then the question is, does the loss arise out of the use of a vaccine? Now, you argued in response to Judge Timkovich that, well, it's not a cause, it's a condition precedent. But to follow up on Judge Timkovich's question, isn't that answer fatal to your whole argument based on the terminology of the statute? You have a loss, at least for some of the species of recovery that you include in paragraph 37 in the prayer, and you cannot have a loss without that condition precedent. That's what a condition precedent is. And if the use of a vaccine is a condition precedent, why isn't that combination a very simple paragraph to reverse based on the argument we have a loss and we have a condition precedent that arises out of the use of a vaccine.
I'll start by saying I agree that you don't need to look to congressional purpose or legislative history if you have a statute that's clear on its face and plain on its face. But literalism does not equal good textualism. And so I think AstraZeneca's position is, well, the word all means all, and you can ignore the context in which this word is placed in the statute as well as the congressional purpose. Our position is that there's ambiguity in this statute. It definitely does not ever mention contracts. So the court has to read contracts in or has to read contracts out. And when you have some ambiguity, it's really critical that you look to the purpose and then ask yourself which construction of this statute is going to best further congressional purpose. Is it the construction that will allow pharmaceutical companies to lie through their teeth the clinical trial?
I think you've made that point very well several times, and your time has expired. Judge Bacharach may have some more questions, but I think you don't need to go any further on that point.
I do have a follow-up question, if I may. I'm just looking at the PrEP Act and going back to the statute, and we've been talking most about Part A, which is the definition of a loss, which includes mostly tort-like damages. But Part B is scope, and in the scope paragraph it says the immunity applies to any claim of loss that arises out of clinical trials. And so it looks like Congress was envisioning harms or losses coming out of clinical trials. How would you square that with your argument?
I think that's clear. I think Congress absolutely envisioned things like people getting injured by a vaccine during a clinical trial, and Congress did not want those people to sue the company for that injury, right? The legal injury there, Your Honor, is the injury itself. Here, the legal injury is not the vaccine injury. The legal injury here is that AstraZeneca breached its contractual obligation. That is the legal injury for which we seek relief. I do not think, Your Honor, that Congress ever once contemplated the scenario that is here, where a company seeks to escape its contractual promise. And so that would be my response. And lastly, I would note that, as the court noted earlier, even if the court were to construe the PrEP Act as encompassing contractual violations, this case is not ripe for dismissal because we have two separate pathways for overcoming that through both waiver and estoppel. And as even AstraZeneca has conceded in its brief, these are issues that do require factual development. One is a pure issue of fact, or mostly an issue of fact, and the other is a mixed question of fact and law. So I would
that's understood. That's not a dispute. Did you have another question, Judge Bacharach?
Oh, no.
Okay, because I have a follow-up question. It wasn't that long ago, during my life as a lawyer, that there was a lot of controversy or difference of opinion regarding malpractice cases and to what extent it was a contractual claim or a tort claim. If you got a bad result from surgery, was that breach of contract or was that tort? Things like that. Are you saying that if a state decides to recast its more recent cases that have generally treated these issues as tort claims and called them contract claims, that then the suits under those contract claims would not be covered by the PROTECT Act? That it's just a matter of nomenclature?
I don't think so, Your Honor.
Why not?
Well, we sort of addressed this down below, where AstraZeneca was trying to characterize this case as a breach of warranty kind of case that you see within, or an implied warranty case that you see within product liability, which are sometimes called contract actions.
Yeah.
At the end of the day, those actions have their fundamental roots in tort. And so you can't just, this is not just a matter of semantics. You can't
you're saying breach of warranty is really fundamentally based on tort law? Is that what you're saying?
Yes, in the product liability context.
Well, why can't we say your contract claim is fundamentally based on tort law?
Because
how do you decide whether it's fundamentally based on tort law or not?
Well, Utah law provides guidance on just that issue. Is there a written promise, the breach of which gives you a cause of action? And so in here, that's what we have. We have a written instrument with a promise that was broken. And that is a very distinct cause of action from implying some type of warranty that then becomes termed a contract. I think that type of cause of action, you can't escape the PrEP Act through that kind of semantics. But where you have a company that is expressly promising something in an enforceable written contract, that is a distinct cause of action. And I think it's important to note that this is not something that has caused any issues with litigation in the past. This is not something that's going to open the floodgates of litigation. This is entirely within the control of pharmaceutical companies like AstraZeneca to simply not make promises if they're not prepared to keep them. Then there's no further liability.
Okay. I think in terms of exhaustion, I think we've exhausted your arguments at this point. Mr. Anderson has reserved some rebuttal time, so we'll hear from him. Thank you.
Thank you, Your Honors. I want to address 3 points in rebuttal. First is the comment that the statutory text does not include an express invocation of contracts either way. It also doesn't include an express inclusion of statutory claims, but those are immune, as we saw in the Red case. It also doesn't say federal constitutional claims are included, but as the Ninth Circuit found in Manny, they are. All claims means all claims. Congress was not interested in legal labels. It wanted to see if there was a loss, as broadly defined by the statute, and if so, and it was caused by the administration of a vaccine, all claims that could be brought for that kind of loss are immunized. The second is the idea of the unequivocal promise. First of all, I want to read from what the informed consent form says. But before I do that, nothing in an informed consent form can change the statutory meaning of the PrEP Act. That is an independent question, as Judge Hartz has reminded us a few times. But here's what the contract says. You may be prevented from making claims for injuries that have a causal relationship with the use of the investigational product in this study. And it goes on to say, including but not limited to claims for death. It essentially replicates the text of the PrEP Act without naming it by name.
What page of the consent form was that? Did you read from?
I'm reading from page 62 of the appendix. That may be the easiest way to find it, Your Honor. Lastly, the absurdity canon. All means all, and interpreting it that way is not absurd. This was a deliberate, if difficult, policy choice by Congress. Reading the text faithfully is not just good textualism, it shows respect for Congress's constitutional role in setting national emergency policy. It recognizes that Congress used broad language throughout. Any claim, all claims, loss means any loss, using a causation standard that is as broad as we get in legislative text, arising out of, relating to, caused by. It faithfully honors the careful balance that Congress struck. It was faced with a national emergency in 2005, recognizing that our industries were not equipped and were deterred from being able to prepare our country for the rapid development and deployment of life-saving vaccines in the event of a crisis. Honoring the balance that they struck, broad as it may be, directing injuries that are caused thereby to the federal compensation scheme is not absurd. Respectfully, this is a heartland case for immunity. The factual predicate of this case, in Ms. Dressen's own words, are the personal neurological harm from the vaccine. That is precisely the circumstance that the text and purpose of Congress sought to immunize. We respectfully ask this court to reverse the judgment below.
Thank you, counsel. Thank you both. Case is submitted. No more questions, I gather. I should have checked. Okay.
No, none.
Case submitted and counsel are excused.
Thank you, Your Honors.
Thank you, Your Honor.
Could we go ahead and take our break now?
Sure. We'll be back in 10 minutes at 11 o'clock.
Thank you.
The Honorable Judges of the United States Court of Appeals for the 10th Circuit.
Thank you.
Wrote one in the PLCAA. That's the fire.
24-6132, Devon Energy Production Company versus Department of Interior. And we'll start with Mr.
The Honorable Judges of the
All these names are difficult for me. Legit or Legit?
Your Honor, may it please the court, Poe Leggett.
Leggett, I apologize. And you look familiar, so I probably mispronounced your name in the past too. I apologize.
You can call him Judge Hertz.
The district court, I would like to reserve, I'm here for Devon Energy. I hope to reserve 3 minutes. We'll see.
Yeah.
The district court incorrectly upheld an Interior Department order demanding more royalties on natural gas. Between 2004 and 2008, Devon produced gas from 2 geological formations in New Mexico. One was coal bed methane containing a high amount of the pipeline contaminant, carbon dioxide. The other was conventional gas, which lacked contaminants, making it unmarketable. 2 different midstream companies transported and processed Devon's gas, Williams and Enterprise. One company charged a so-called bundled rate, meaning it was one fee for all services under the contract. The other charged a partly bundled fee. Adhering to a 1997 settlement between Devon and Interior, Devon did not deduct from its royalties 7.78 cents per 1,000 cubic feet to remove excess CO2 from the coal bed methane. But the order assumed Devon had deducted all bundled charges anyway. It also assumed Devon's conventional gas was not in marketable condition. It also disallowed all Devon's deductions, and finally it ordered Devon to separate marketability costs by unbundling the 2 transportation systems it had used. It gave Devon 2 alternatives. One was to take no allowance at all. The other was to use the department's non-binding UCAs, unbundling cost allocations, for these 2 plants. But if Devon used those 2, the government would still come back later and audit Devon to make sure that the UCAs accurately reflected Devon's actual costs for these 2 systems.
Didn't the Department of Interior also say that you could calculate your own transportation costs through your own methodology?
Your Honor, they did say that in their response brief on this appeal, and that is incorrect. The department's position is that actual costs means the cost of the system that the company is actually using. And in a moment, I will find you a citation to the appendix for that.
Okay.
So your review is de novo. The errors are that the order ignored the coal bed gas settlement. Second, it violated a statutory duty to identify Devon's errors and give facts and reasons for treating the conventional gas as unmarketable. If the court disagrees with me on either of those points, then our due process argument must be considered.
Let me back up on the costs. If you have a bundled price from a company like Enterprise, and it charges, this covers all the things we might do to your gas, including making it in marketable condition. But it turns out that your gas is already in marketable condition when it enters their system, so they don't have to do anything. Aren't you still paying some money to Enterprise to have them available to take out contaminants if necessary? And even though it turned out that it wasn't necessary, we spent money on that, and that should be deducted from our expenses. How does that work?
I'm sorry, Your Honor. That has not been the department's position before, because it is pretty easy to determine whether a processing plant has had to treat gas that had become unmarketable. It's a simple matter of taking the gas analysis report and comparing it with the pipeline physical quality specifications and seeing if our gas analysis has higher numbers than what the pipeline allows. And in those cases, there might be a need to go unbundle. But the evidence here was that throughout the period, the gas was well below standard for the only contaminant that was even mentioned in the record, and that is carbon dioxide.
So there are records kept of this I'm sorry. So there are records kept of this that someone can look at and say that this gas was in fact the not the coal bed gas, but the other gas, conventional gas, is that what it's called? That it was always in marketable condition when it got to the processors?
That is correct. And
do we have that in the record?
We do. It should be in second or third appendix at, I believe it's 389. Try to confirm that very quickly.
As you're finding that, Judge Hartz, do you mind if I follow up with
please?
Let me test you, not test you, but ask you. That's not my recollection. My recollection is that Devon responded to the audit saying that the Mesa Verde formation generally satisfied the carbon dioxide limits. I don't remember the word always. It used the word generally. And in fact, I think that's the word that you used in your appellate briefing. And so let me just ask, assuming that I'm right, and I might be completely wrong, if you did deduct 100% of the cost of putting the Mesa Verde formation gas, the conventional gas, through the treater and said, well, that wasn't to make it in marketable condition because it was already marketable. If 10% was unmarketable, exceeded the threshold for carbon dioxide, and 90% was marketable, and you're deducting 100%, they weren't saying that you didn't have, that 100% of that was non-deductible. They're just saying you have made a systematic and repeated error in the way that you are reporting to, to the state tax division. So why isn't that a problem if it was generally marketable under the carbon dioxide threshold, but not always?
The word generally was in a letter to the government that, as I recall, was covering the general span of the history of audits on these properties, which go back to 1990. During the audit period, the government had an opportunity to identify whether there were cases when we exceeded carbon dioxide specifications. And Your Honor, if they had, then your premise would be correct. It would have been our obligation to go in and figure out if the findings were correct, and if so, try to come up with a way to unbundle.
Okay.
But the record doesn't show that here.
And you're saying, as I understood you to say a couple of moments ago, that in fact the record shows that it was marketable, that all of the gas that came to the processors was marketable. That's apparent from records kept at these facilities over the years. Is that correct?
That is correct, Your Honor. A lot of the records are not in the appendix. One that will illustrate the point is at appendix 389. I think that's volume 3. But it shows carbon dioxide readings. And here the government has not stated in the record what it thinks the marketable condition level is. Historically, in this area, they've said somewhere between 2 and 3%, but they've taken no position on that here. So there's no way for me to argue or for the court to determine from the record whether Devon was in violation of the marketable condition cap on CO2.
Good. You may proceed.
Okay. I'll go back to the settlement agreement. The decision clearly ignored it, and the rule that the court should apply is the important aspects test that was illustrated this summer in American Wild Horse Campaign 144 F4th at 1190. There, BLM had considered many aspects of wild horse management, but it had failed to consider maintaining a thriving natural balance. What made the natural balance issue important was that the statute required it. BLM ignored it. This court overturned it, even though it had properly considered some other issues. Now, the district court here felt that the rule did not apply because the settlement only covered coal bed methane, not also natural gas, conventional gas. But the test is an important aspect, not all aspects. And by legislative rule, the royalty settlements outrank the actual text of the royalty rules that the government is trying to apply here. So by binding Interior Department regulation, they have made the 1997 settlement an important aspect, meaning they at least had to consider it, and they didn't do that here.
Didn't the district court say that the 98 settlement had expired?
No, it didn't. It didn't reject the settlement, but the reason for your question is that I think it's fair to say the court may have besmirched without finding, because it's at footnote 14 in its opinion. The issue there was that there are two parts to this settlement, a transportation rate and a treatment rate. At the time of the settlement, the transportation rate was set by 3 contracts with specific cents per MCF values. And so that's what the parties used in the deal. Those were set to expire in 2000, but just the transportation rate was set to expire. The treatment rate did not contain similar language. We explained to the district court, and this was the only thing he took issue with, was that when those transportation rates expired with the contracts, we would be required to use the next round of contracts. He said he didn't see the support for that. The support for that is because the regulation would require us to use the new contract. Those would be our arm's length rates. So that was his question, but he never said the settlement had expired.
So the contracts setting the transportation rate had expired, but the contract setting the treatment rate had not. Is that?
Well, the treatment rate was not a contract number, Your Honor. It was agreed to by the department and by Devon. And because figuring out treatment is a cumbersome issue, they agreed on a fixed number to go forward.
And why would they continue that rate but not the transportation rate? What's the purpose of distinguishing them?
Well, I do not know, and the record does not reflect why the parties drew that distinction. And the only reason would be to make clear that there were 2 rates, and they wanted to set them all in cents per MCF rather than existing contracts, future contracts for transportation. That's just the language they decided to use.
So if this were remanded for the agency to review whether the settlement agreement affected the arrangement, that's the sort of thing that would have to be pursued on remand, is figuring out whether the contract really does terminate the treatment rate agreement or not, depending on what the purpose of treating the treatment rate differently from the transportation rate, whatever. Is that fair to say?
It is. They would also have to consider the arguments they declined to consider and the district court declined to consider on the actual text of the agreement about how no language limited the treatment rate to a time period, and the department's acceptance of the treatment rate after the settlement.
Yeah, okay.
A whole long line of cases on that. Yes, but yes, Your Honor.
You've got a few seconds left.
All right. Well, on due process, you've already, I think, put your finger on it with one of the first questions about the availability of other rates. No, they won't accept those rates, and it's a post hoc argument. My time is up.
Thank you, counsel. Mr. Adams, you may proceed.
Good morning, and may it please the court. John Adams on behalf of the United States Department of Interior. Plaintiffs' appellants have put forth many arguments for the court to consider, but the overarching issue is whether, under Section 1724 D4B, Honor properly ordered Devon to perform a restructured accounting when Devon unilaterally reduced its royalty payments to our public fisc for public resources it had extracted from our public lands. Already, we have discussed at length the settlement agreement, processes, and CO2, so I'm just going to jump right there. Devon argues that the 2016 order requiring it to perform a restructured accounting is arbitrary and capricious because Honor did not consider the settlement agreement. For a few reasons, Devon is wrong. To begin with, I'm just going to take a step back and I'm going to contextualize a little bit more the 2016 order. The agency issued an order for Devon to perform restructured accounting. In plain terms, this requires Devon to perform a reevaluation of its financial records, including unbundling costs to disaggregate improper allowances. Importantly, this is just one step in a comprehensive process to allow the agency to review the correct royalty rate that Devon owes the United States for extracting natural gas on public land. During this process, Honor will still consider the settlement agreement. It'll still consider the CO2 that we heard from counsel. Whether this court affirms or remands, the agency is just requiring Devon to show its work for its claimed allowances. And let me describe just in a little bit more detail what will happen whether this court affirms or remands. And this leads to my second point and why the district court got it right. As the district court found, plaintiffs did not contend that the settlement agreement pertained to all production or that a methodology established by the settlement agreement encompassed all transportation and processing allowances.
Why wasn't it a significant part of the problem when there's no dispute that it's 82% of the disputed royalties?
Your Honor, that is a disputed fact, and Devon is asking this court to engage in fact-finding when the agency is still going through the process right now.
Well,
we don't know.
I'm not. Let me. I didn't mean to talk over you, but let me just kind of reframe the question. As I understand it, tell me if I'm wrong. That one of the issues is, did the government owe the Department of Interior fail to consider a significant, part of the problem when they decided that there was a systematic and repeated irregularity in Devon's reporting. So they say, well, when they get the audit letter from the state, they say, well, we have this settlement agreement. They make the argument that counsel made today that the treatment costs for 7.78 continues in perpetuity. They make that argument. The agency doesn't address it at all. And now, true, if there's a restructured accounting, maybe they'll decide it now. But before we can affirm, don't we have to decide that OSMRE did not, or I may be getting my agencies wrong, failed to consider, that the Department of Interior failed to consider a significant part of the problem. I mean, they've said it is 80% of the disputed royalties. I don't remember seeing anything in your brief saying, well, it's not 82%, it's 68%. It's a lot. why isn't that a problem since the government clearly did? I mean, the word settlement agreement don't appear in the order.
Understood, Your Honor. The settlement agreement was attached, and it is the Office of Natural Resources Revenue, or honor. That's what I mean by saying honor.
I'll call it that.
And let me just point to the court, to the record, about an important factual finding that's undisputed that honor made here. Honor on Appendix 176 found that in the agreement, Enterprise and Williams, I'm paraphrasing, it's EFS and WFS, but it's Enterprise and Williams, those are third-party vendors that Devon contracted with, quote, provide gas gathering, dehydration, treating and processing services for a single bundled fee. And then the factual finding goes on, the services provided include functions required to place gas in a marketable condition, end quote. So, Your Honor, to answer your question, we just don't know what costs Devon has paid for those services. Devon says right now that the settlement agreement covers CO2, but as the agency found, the contracts with the third-party vendors cover way more than CO2. It covers gathering services, which this court found an API against DOI just 2 years ago, are not allowances that a lessee can take from a royalty rate that it owes the federal government. And the restructured accounting order is just asking Devon for more information to prove up its allowances. It may very well be the case that the settlement agreement eventually may touch upon some of the costs that Devon pays these third-party vendors. We just don't know. The agency is just asking Devon to show its work, and that's what the order is doing right now. And so, to answer your question more pointedly, if the court affirms, the agency will continue to consider the settlement agreement, even whether it expires, which it does.
So, doesn't the agency have to make some supportable finding of underpayment before it starts the process that it initiated 9 years ago, 8 years ago? Does it not have to do that?
In 2016, well, it did. It made a preliminary finding that Devon had been underpaying its royalty rate, and then issued this order.
Well, it made that finding, and what Devon is saying is there was no basis for the finding. Is that a correct statement of what's at issue here?
I think Devon argues a few bases that it contends renders the order arbitrary and capricious. And to your point, Your Honor, I think this goes into counsel's argument where Devon asserts that the 2016 order was arbitrary and capricious because Honor did not prove that the gas was in a marketable condition, so making a factual predicate finding. But the district court got it right when it concluded that Honor's reasons for the 2016 order did not depend on quality specifications for marketable gas, but on the regulations that state categorical rules regarding deductible allowances. And those categorical rules...
I understand Devon's position. It's two parts. Combining to show that there's no reason, no sound reason for the agency to have ordered this process to start. With respect to coal gas, saying there's a settlement agreement that covered that, and that supersedes any regulations. So for all the Fruitland coal gas, and I think there was coal gas from another area, that's resolved by the settlement agreement. And for conventional gas, there's no evidence that it wasn't marketable before it went to the processor. So there's no evidence of any processing required to make the gas marketable that should not have been deducted. And if those two, if Devon is correct about that, didn't the agency have to explain why it rejected those contentions? Either explain that, address the settlement agreement and explain why it thought it had expired, maybe not prove it, but at least address it, and also address why it thinks that Devon was paying to have conventional gas brought to marketable condition. What's wrong if I'm construing their position correctly? and you can correct me on that, but what's wrong with that argument? Go ahead.
The evidence shows, Your Honor, that Devon had a contract with third-party vendors, specifically Enterprise and William, to provide functions that require it to get its natural gas into a marketable condition. And we just don't know the extent to which those costs, how much Devon was paying for those costs. But the contract itself that the agency cites in its 2016 order at Appendix 176 is the evidence. And Judge Bacharach, to answer your question that you asked counsel earlier about whether, with respect to the conventional gas, it was in a marketable condition, you're exactly right that Devon had stated in the record, and I'll quote it, Devon's conventional gas generally does not require treatment to be in a marketable condition. That's from its opening brief on pages 38 and 39, and it's citing Appendix 267. And so there are a lot of facts out here that we just don't know. And what the 2016 order does is require Devon to just show its work, to show its unbundled costs for the cost that it's paying Williams and Enterprise to put its gas into a marketable condition.
Why wouldn't it be satisfactory for Devon to say the settlement agreement applies and the agency is compelled to accept the whatever cents it is per MCF has the cost of making the coal gas marketable, and then supplement that with showing that there's no indication, in fact, the record is to the contrary. The record shows that the conventional gas was in marketable condition when it got to the processor. Would you agree that that would be sufficient response by Devon?
No, Your Honor.
Why not?
Because Devon's paying for services to put its gas into a marketable condition, and the agency is just asking for an unbundling of those costs. I'm not aware of why Devon is paying for these costs if it contends that its gas is already in a marketable condition. And all the agency is asking for Devon is just to show its work and to prove that its gas is in a marketable condition, or it's not paying for costs or functions or services related to putting its gas in a marketable condition that this court's decision in API against DOI or even the federal regulations, 30 CFR section 206.152I, does not allow any lessee to deduct those costs from the royalty payments it owes to the United States.
But I thought one thing Devon was saying, let me pursue this a little bit. We'll give everybody on the bench some time to ask questions.
Right.
I thought Devon brief was saying that these particular services you say are used to make the gas marketable are services that are used for other purposes. There's no evidence that these services were used to make the gas marketable. In fact, the marketability processing is done upstream of, well, you know the point I'm making. How do you respond to that?
It is true that there are regulations that do allow for these types of costs. The point that the agency wants to make is that we just don't know where those costs fall in. It could be the case that Devon is performing or the third-party vendors are performing services for Devon that fall within another regulation. And it could also be the case that they're performing services for Devon that fall within a prohibition of Devon taking allowance from the royalty that it owes. We just don't know. And that's why it's important for Devon to unbundle its costs to show its work so that the agency can make that assessment. But that's part of the process point I tried to make earlier.
Go ahead.
Doesn't the Royalty Fairness Act, though, require a factual basis for that determination? And you're just really speculating that there might be a problem. But don't you have to do more than that? Basically, what you've done with the order is shift the burden of proof to Devon, i.e. to show its work, to prove its costs, rather than you making a factual determination that there's a problem with the submitted deductions that they're taking. Doesn't that invert the statute?
No, I don't think so, Your Honor. You're right about the statute, and the factual finding that we point to in our brief is the contract that Devon entered into with its third parties. And we contend that it is still Devon's burden to prove those costs. The agency just doesn't have that information and it's just asking Devon for it.
Can the agency get that information from the transport company or the processor?
Not that I'm familiar with, Your Honor.
Well, here's what troubles me, and maybe this is something that's to be handled in the future, but it seems to me that if in fact the settlement agreement was still in force, so marketability cost for the coal gas is taken care of through what Devon has paid consistently by applying this settlement agreement figure. And it's also true that Devon is not submitting, the gas Devon is sending to the processors is already marketable, then Devon shouldn't have to do anything more. There's no need to unbundle any cost. But you're imposing on Devon a burden to do something that it shouldn't have to do if its two, I'll say, fundamental assertions are correct. And that seems unfair. If all you're saying the agency has done is said, we've got some questions, you need to answer it, then Devon should be allowed to answer the question by saying the settlement agreement, by showing that the settlement agreement is still in effect and that the gas it's submitting to the processors is marketable. But your order doesn't seem to allow that. You say you have to unbundle the cost, which is a major undertaking, particularly when they don't have access to the data from the processors. It would comfort me if you said they could do all this downstream from this proceeding, but they ought to have a chance to make that their case to the agency at some point. What am I missing?
Well, I would just revisit, I see that amount of time, so I'll succinctly say that I would just revisit my arguments earlier about if this court affirms the settlement agreement is still in play. Devon it just applies to CO2, but the contracts that Devon has with the third-party vendors cover way more than that. So the settlement agreement, as the district court found, will not resolve the unbundling issue, nor will it resolve this case. Devon still has to contend with other services that it's paying for these third-party vendors. And if I'm wrong about that, Your Honor, and the court is inclined to remand, the proper course on remand would be to remand without vacatur for the agency to consider the settlement agreement and to consider whether it expires, which we contend it plainly does.
Well, would they have an opportunity on remand to show with the records that counsel referred to that the conventional gas coming to the processors is already in marketable condition? Is that something they could do to resolve this in conjunction, in combination with showing that the settlement agreement was still in force? Would that be adequate?
Yes, Your Honor. The agency will consider arguments, will consider records, of course. I think Devon's going to have to contend with the record evidence already that states that its gas was generally in a marketable condition, and what that means, and whether it had to do some type of function or service to put its gas in a marketable condition. But the agency will consider arguments and records, of course.
Of course. It sounded to me, the way I saw the order, they had to unbundle the costs, which is a massive undertaking, perhaps an impossible undertaking. And what they're saying is it's a totally unnecessary undertaking because the gas was marketable. So I'm not sure that the agency position allows for what would seem to be fair here.
Well, Your Honor, I just want to point out, I think you get into the impossibility argument that Devon has asserted in his papers and an oral argument this morning. The order itself offers alternatives to Devon to comply with it. It doesn't have to unbundle its cost. It can take the unbundling cost allowances, the UCAs that the government explains to it in its response brief. And then
were there any this period that we're talking about is 2004 to 2008. And these UCAs, as I understand it, didn't begin until October 2009. So how could they have used the UCAs?
They can use them now, Your Honor. That's what the
They were
order is.
retroactive?
Correct.
Okay.
And then I just want to clarify one thing. As we stated in our brief, Devon also may do its own unbundling calculation, and the citation for that in the order is Appendix 182. That's something that dozens of other lessees do with the agency, and historically, most of the proposed unbundling methodologies proposed by the agency are accepted.
Could they use then their transportation costs at their other off-site leases?
Yes, Your Honor. They can submit methodologies for honor to consider and approve. And
No,
yes,
they can submit anything that they want, but does the government accept those, or are you going to say no? Those are dissimilar.
Well, I don't know. I would have to see what they submit, but the point is they are free. Other dozens of lessees have done this with Interior, where they submit their own proposed methodology, and there's a lot that goes into it about the specific site, the specifications of the gas and everything. I can't speculate on what the future might hold, but if it's a reasonable submission, I mean, mind you too, the regulations only require reasonable actual costs. Devon reads the reasonable word out of it and just says it's only actual costs, but it's reasonable actual costs. And Devon is free to submit its own methodology to obtain the reasonable actual cost that is required by the regulations.
Thank you, counsel. Case is submitted and counsel are excused. We can turn to our next case momentarily. Okay, we'll now turn to 24-6221, Comanche Nation versus Ware. Mr. Carter, you may proceed.
May it please the court. My name is Daniel Carter, and I represent the appellants, the Fort Sill Apache tribal officials. I'd like to reserve 4 minutes for rebuttal. Comanche Nation's action to shut down the Fort Sill Apache Tribes Casino is barred by sovereign immunity. Each of Comanche's 3 theories for circumventing sovereign immunity fell because 1, the Indian Gaming Regulatory Act, or IGRA, does not abrogate tribal immunity for this type of claim. 2nd, Ex parte Young is unavailable here because, among other reasons, express statutory remedies in IGRA and RICO bar its use. And 3rd, the tribe is the real party in interest, so even individual capacity claims are barred. The district court's order permitting 2 claims to proceed should be reversed and this case dismissed in full. Starting with the first point, there's no abrogation of sovereign immunity for Comanche's claims in the IGRA. Comanche invokes 2710 D7A2, but that provision applies only when the gaming occurs on Indian lands, there's a violation of the Tribal State Gaming Compact, and the relief sought is to enjoin Class 3 gaming. To avoid the Indian lands limitation, Comanche argues that the gaming occurs on Indian lands of another tribe, the Kiowa tribe, but that argument fails. This land has been held in trust for the Fort Sill Apache tribe since 2001, and Comanche did not challenge that acquisition for almost 20 years later until they filed this claim. The district court correctly rejected Comanche's claims and dismissed the claims and the federal defendants as a result. This case is on all fours with Bay Mills, which held that if an argument or a claim argues that the gaming occurs outside of Indian lands, that there's no abrogation of immunity. And even
what I don't understand, Mr. Carter, is you're saying it is Indian land. It's the Apache's Indian land.
Yes, Your Honor, it is the Apache's Indian lands. But if it's the Apache's Indian lands, Comanche's not making a claim that it's in violation of the IGRA.
They may lose on the merits, but I don't understand why that would vitiate their reliance on IGRA as an abrogation of tribal immunity.
Well, there's another reason why it does not fit in that abrogation. That's because there has to be a violation of the tribal state gaming compact. And without a violation of the compact, then there's no abrogation of immunity. The compact
that's kind of circular. That seems to say any claim under IGRA, there's not jurisdiction for any claim under IGRA except correct claims, valid claims, because the claim under IGRA is there's been violation of a compact. And if there wasn't any violation of a compact, then, hold on, I'm going to get this backwards. I'm going to assume that you know what I'm trying to say and respond because...
yes, Your Honor. So in Bay Mills, the court held that a claim that the gaming is not occurring on Indian lands falls outside of the IGRA. There could be a violation that falls within IGRA if the claim falls on Indian lands and it's in violation of the Indian Gaming Regulatory Act and the compact. So IGRA envisions states and tribes having class 3 gaming compacts, and IGRA allows a state to sue a tribe for a violation of that compact and for a tribe to sue a state in violation of that compact. The reason it sounds circular is because IGRA doesn't envision third-party claims against tribes or tribes against another tribe.
Well, Comanche argues that you're running an illegal casino and that's injuring them, and that casino violates IGRA, where the state tribe compact. And doesn't the statute basically say any tribe can sue over the violation of a contract? And and they do have to show an injury, but haven't they plausibly alleged in the complaint an injury that's caused by the operation of the casino? So what am I getting wrong about that? Why does the statute exclude Comanche from pursuing this claim?
Because 2710 D782 only permits claims in violation of a compact. If Comanche's claims are correct, that it is the Kiowa tribe that owns these lands, then it falls outside the compact entirely. And that's this court's decision, Oklahoma v. Hobia, that's on all fours with Bay Mills as well. In addition...
No, what do you mean it falls outside the compact? It means it's not permitted by the compact, which means it violates the compact. And that's that's the basis for IGRA.
No, Your Honor, IGRA does not govern gaming outside of Indian lands. And the compact...
Right, but we're not talking about... But there's no dispute that this is Indian land. Your claim is it's not the land of the party running the casino, of the tribe running the casino. That's your argument, I think.
Well, my argument is that it's Fort Sill Apache's Indian lands, so there's no violation. But Comanche alleges that it's Indian lands of the Kiowa tribe.
Okay.
And the compact only governs gaming on Fort Sill Apache Indian lands. It doesn't
when you say it doesn't cover, what you should say is the compact doesn't permit gaming that's not on the land of the tribe running the casino. That's why it's circular. You're saying they have to have a valid claim. If they don't have a valid claim, then there's no violation of IGRA, so there's no waiver of sovereign immunity. That's essentially your argument, the one I got mixed up in my mind before. You're saying that because there's no violation of IGRA, there's no waiver of sovereign immunity under IGRA. That's fundamentally what you're saying, is it not?
No, Your Honor, because the scope of the compact only governs gaming on Fort Sill Apache's Indian lands. It doesn't prohibit gaming outside of Fort Sill Apache's Indian lands. It only governs...
But wait, how is the compact structured? I would have thought that the compact says this allows this sort of gaming at this location. And to the extent that it doesn't allow something, it's prohibited, because the only way that you could have lawful gaming is under the compact. What am I missing there?
Well, Your Honor, at the outset of the compact, it states that the compact governs gaming on the Fort Sill Apache's Indian lands. But nothing prohibits in that compact from a tribe or the Fort Sill Apache tribe from getting a state license, for instance, to game on fee lands or on another parcel. IGRA's scope only relates to tribal gaming on its Indian lands. The same for the compact. It only governs the tribe's gaming on its own Indian lands.
Well, they're arguing that the disputed lands here, the Fort Sill lands, that were created after the passage of IGRA, and therefore they're not permitted to host a casino facility. Is that their argument?
That's one of their arguments, Your Honor. And again,
what's wrong with that argument?
Your Honor, that would not fall within the compact, and it would not fall under the IGRA, because lands that are taken in trust after 1988 are again outside the scope of the IGRA and the compact. And there was a decision on point in the Seventh Circuit related to this, which was the Stockbridge-Muncie community versus Wisconsin. The Seventh Circuit said that the act does not entitle anyone to prevent gambling that is altogether outside the statutory scope, such as gambling on private land or on land taken in a trust for a tribe after October 17th, 1988. So it doesn't prevent gambling on those lands. It doesn't even address or govern gambling on those lands. And finally, 2710 D7A2 is limited to only injunctive relief against Class 3 gaming. What Comanche seeks is to shut down the whole casino, including Class 2 gaming. And so for that third reason, Comanche's claims do not fit within that abrogation. Comanche also seeks to utilize the Ex parte Young exception to circumvent the tribe's sovereign immunity. But Ex parte Young is also unavailable. In Seminole Tribe versus Florida, the Supreme Court held that the detailed remedial scheme in 2710D prohibits implied remedies. And this court also held the same thing in Hartman versus Kickapoo. The 10th Circuit is very clear that if Congress provides an express remedy, it bars implied remedies. And here, Congress provided an express remedy for claims that are in violation of a compact on Indian lands of a tribe. Hill versus Kemp, Sage versus Hickenlooper, this circuit's arguments, it's very clear that if Congress has an express remedy, implied remedies are barred. That's exactly what Ex parte Young is an implied remedy. So that should end the Ex parte Young exception on its own.
Can I ask you about that, Mr. Carter? My understanding is that case law was predicated on a delay in negotiating in good faith for a tribal state compact. And so I thought that the idea underlying those cases is that you can't have some sort of free-floating claim for an injunction based on some common law theory when Congress has specifically articulated in IGRA a specific mechanism for resolving disagreements between a state and a tribe when one party is ostensibly failing to negotiate in good faith. But I don't understand how that, if my understanding of that case law is correct, why IGRA would, why the creation of a statutory remedy in IGRA that the Comanche tribe is invoking, that seems to throw that seems backward. They're not invoking a free-floating theory. They're invoking the very detailed remedial statute that you're pointing to.
Well, Your Honor, the facts of Seminole Tribe did relate to failure to negotiate a compact in good faith, but the analysis related to 2710D as a whole. The remedy set forth in 2710D7 relates to, or all of 2710D relates to compact negotiations and enforcing compact. The analysis in Seminole Tribe is still applicable here. And the important part was that when Congress provides an express remedy, it bars other remedies. And that's what Congress did here in 2710D7, is provide an express remedy, although it's modest, it's specific, and courts cannot read into additional remedies that provide broader relief when Congress specifically provides remedies.
Maybe I misunderstood what you said earlier. I thought you had said earlier that IGRA specifically contemplates one of the one of the prescribed remedies is a remedy for the violation of a tribal state compact. Did I misunderstand?
Yes, Your Honor. When the state sues a tribe for violating that compact and the gaming occurs on the tribe's Indian lands, there's a specific remedy. Congress easily could have drafted a remedy where a tribe could sue another tribe for violating a compact or for gaming outside of Indian lands, but it did not, to the exclusion of the type of remedy that Comanche Nation is seeking right now.
May I ask something about the compact? Does it have any description of the geographical area that the compact covers? And in particular, does it say anything about a casino at the location where we're talking about here?
No, Your Honor, it doesn't. If you look at the compact just states at the outset what the scope of the compact addresses. And it states that it addresses gaming on the Indian lands of the Fort Sill Apache tribe. There's nothing in the compact that prohibits gaming outside the Indian lands. The compacts just govern, how a tribe will perform its gaming, how much auditing rights the state has, what reporting requirements there are. It doesn't address where a tribe can game or where it can't game. And that's why it's outside.
It does here. The compact is for gaming. Would you read that language you just read a moment ago? I thought you said it's on the Fort Sill by the Fort Sill Indian tribe on the Fort Sill reservation or something like that. What did it say?
Your Honor, it's on the compact covers Indian lands over which the tribe has jurisdiction and the Indian lands of the tribe. That's all it governs. That's all it regulates. It doesn't prohibit or govern gaming outside of the compact. It only governs gaming.
Okay, so if it's land that Fort Sill doesn't have jurisdiction over, which is essentially what the complaint argues, right, then it's not covered by the compact. So there's no way it could violate the compact. It's just not covered by the compact.
Exactly.
Your point is, okay.
If you're right, Mr. Carter, is there any forum where Comanche could pursue these claims?
I'm not sure about Comanche, but there are plenty of remedies in the Indian Gaming Regulatory Act for unlawful gaming. For example, the NIGC could issue a shutdown order of a casino, and that's Your Honor, may I finish answering the question?
Yes, please. Yeah.
The NIGC may issue a shutdown order of the casino if it's not on Indian lands. If it's outside of Indian lands, the state would also have prosecutorial jurisdiction and regulatory jurisdiction over that gaming, assuming sovereign immunity doesn't apply, but the regulations would still apply nonetheless. And the United States could also have criminal enforcement jurisdiction for unlawful gaming under statutes such as 18 USC 1966 or 1166, excuse me, and 1955.
Comanche would not have a private right of action under any of those provisions.
Your Honor, they could under state law. If the gaming is not on Indian lands, they could have a right of action under state law if the state provides one. But I'm not aware of whether the state provides a private right of action, such as for torts or tortious interference with a business. It's not necessarily prohibited. It's just not covered by IGRA at all.
RICO might have a remedy also.
Well, Your Honor, RICO...
well, you're saying okay. Why don't you address RICO quickly?
Well, in RICO also has an express remedy for private plaintiffs, and it is limited only to treble monetary damages, while the United States can bring an action under RICO and receive injunctive relief. In 1964B is where it provides the United States could seek injunctive relief. And then in 1964C, it specifically states that private parties can only receive treble monetary damages. Again, under Hill versus Kemp and Safe Streets versus Hickenlooper, those express remedies bar implied remedies. So the court should not read into 1964C to say, well, it's limited to monetary damages, but we should also give injunctive relief. That's just not what this court has done in the past, and that's not what Congress prescribed in the RICO.
Thank you, counsel. Your time is expired. Well, any other questions from the panel?
No.
Thank you.
Thank you, Your Honor.
Mr. Pipestem.
Thank you, Judge. May it please the court. Wilson Pipestem, I serve as counsel to the Comanche Nation in this case. My co-counsel, Shoni Blake and Joe Keene, as well as the chairman of the Comanche Nation Force, Tad Nippa, are here on the call. I'd like to focus on three elements of this case. And I think this is what the judges focused first on in the argument just now, that the defendants assert blanket immunity from suit as they operate an illegal casino on lands that are not eligible for gaming under the Indian Gaming Regulatory Act. The IGRA's terms plainly abrogate a tribe's sovereign immunity when one tribe brings an action to enjoin Class 3 gaming activity of another tribe when that gaming activity violates a tribal state compact. Second, the defendants failed to raise many of their arguments at the district court that they raise now, thereby failing to preserve those arguments. The defendants have failed to cite the record for the arguments they did raise, so the court may assume the defendants did not preserve these issues for appeal. Also, the defendants have not argued plain error for any of the positions they've taken on appeal. As a result, the court may consider these arguments waived and decline to review any issues that were not preserved, and we urge the court to do so.
Mr. Pipestem, on your second and third arguments, why don't we have to consider those sua sponte since they involve federal court jurisdiction?
So first of all, because of waiver, the 10th Circuit courts have said, the 10th Circuit case law and the court's rules regarding forfeiture and waiver, which we definitely have here, say that even in the case of sovereign immunity, the court does not have to take and consider those questions. That's a question of discretion of the court. So even though there are questions here that have been raised, many of them don't relate to the issue of 12B1 jurisdiction. They're potentially collateral issues, but we don't think that's appropriately before the court. Many of them have, including a long list of these arguments that are made for the first time. The defendants argue there's no private right of action in IGRA because a remedial scheme does not allow it. There's no citation to this in the motion to dismiss, and there's no plain error argued. They argue that Indian lands at issue, I know that there's a disagreement. We believe there's no dispute that these are Indian lands, but they can't be Indian lands under the Comanche Nation's theory of this case. That's a merits-based argument that was first raised on appeal without plain error. With regard to some of their RICO claims, the issue of whether RICO establishes a private right of action for injunctive relief. First of all, it's a failure to state a claim issue, and it's raised for the first time on appeal. So to the extent that an immunity issue relies on the argument that we failed to allege individual allegations, the defendants abandoned that argument after the TRO briefing. So, and again, many of these issues were raised for the first time on reply. The issue of Indian lands at issue, whether an original Kiowa allotment can be considered after it was transferred to the Fort Sill Apache tribe, that can maintain that tribal status while it was still a Kiowa allotment. That was raised for the first time on reply. They argue any number of issues that are raised for the first time on appeal. So
let me ask about one we probably spent the most time on with the opposing counsel, whether there's a waiver of immunity, of sovereign immunity under IGRA here, and there is a waiver of sovereign immunity, or Congress overruled sovereign immunity for suits by a tribe against Class 3 gaming activity located on Indian lands, and it's clear this was Indian lands, and conducted in violation of a compact. But the way the complaint here is framed, what you allege is this gaming is not on land of the Fort Sill Indian tribe, and therefore that gaming is not covered by any compact. There's no compact that governs gaming conducted by the Fort Sill tribe on lands not owned or governed, whatever the term was, I'm not sure, by Fort Sill. So why does not, are you saying that argument wasn't preserved below, so we don't need to address it? Or are you saying it's wrong on the merits, or both?
We're saying that the compact language itself incorporates federal law. So if you look at paragraph 5L of the compact between the Fort Sill Apache tribe and the state of Oklahoma, it incorporates these questions of Indian land. So it just mentions IGRA's Indian lands definition and the federal process for acquiring Indian lands for gaming purposes. So by incorporating federal law into the compact, it does not say that the compact approves of these lands being the Fort Sill Apache tribe's Indian lands that are available for gaming. It says that that is a question of federal law that should be determined in accordance with federal law and federal processes. So, and that is what we are litigating here, the question of those Indian lands. There's no doubt these are Indian lands under IGRA. We don't dispute that. We do dispute whether or not these lands are were taken into trust under the after acquired provision of IGRA before 1988, the date of enactment, October 17th, 1988, the date of enactment of IGRA, or after. We believe that they were taken into trust by the United States for the Fort Sill Apache tribe after that date. So what is the defendants have raised for the first time on appeal is that this was a allotment that belonged to a Kiowa Indian, and it was under the jurisdiction of a Kiowa Indian. It was in trust for that individual. The United States transferred that land to the Fort Sill Apache tribe after October 17th, 1988. We believe that is a violation of the after acquired provision of the Indian Gaming Regulatory Act. So,
but you have to show, I mean, this waiver of sovereign immunity in the language I read is that it's got to be contrary to a compact.
Yes.
And what you've added is that the compact itself incorporates federal Indian law restricting gaming. Is that what you're saying?
Yes. So by the language of the compact itself, it says that we defer, and this is my words, not the exact language of the compact, the federal processes for acquiring Indian lands for gaming purposes to the United States.
Does Fort Sill have a casino somewhere else?
I believe they do. I'm not sure though. So,
well, if you're right then about
IGRA,
if you're right about there being a violation of IGRA, then doesn't that obviate your ex parte Young theory? In other words, you don't need ex parte Young because you have a direct violation to pursue under IGRA.
We believe in this, the Indian Gaming Regulatory Act. There's a narrow abrogation of tribal sovereignty limited to these sorts of claims. So just the language of the statute we rely on just the plain language of the statute. So in this circumstance, the Comanche Nation's an Indian tribe. We've sued to enjoin illegal Class 3 gaming activities on the Salote allotment that was then transferred to the Fort Sill Apache tribe. We question whether that was a lawful transfer, but at the time, that was the jurisdiction of the Kiowa tribe, and the United States took that land into trust after 1988 for the Fort Sill Apache tribe. So that is a matter on the merits that will, in this complicated world of Indian lands in Western North Carolina, that will we hope to litigate and at the district court. But the language, we believe that we meet the plain language of the statute.
But if you do, I think this was the question. You don't need ex parte Young to get relief then.
We don't need relief from ex parte Young for our IGRA-based claims.
Okay.
So we also say that the ex parte Young, we brought an action under RICO. So we do believe that ex parte Young allows for, does not allow them to raise effectively a sovereign immunity defense in that circumstance.
But the RICO claim is dependent on an IGRA violation, is that correct?
No, it's an entirely separate statute. So IGRA incorporates
the underlying. There has to be an underlying offense.
Oh yes,
and that's the IGRA violation.
Yes. So first we have to establish it's illegal gambling, right? And that is a question under IGRA, because again, we believe that for a number of reasons that we've identified. I just mentioned that the lands here are not eligible for gaming. They're in trust. They're Indian lands, but they are not eligible for gaming for the Fort Sill Apache tribe.
Just to make sure that I understand, so the RICO claim is an independent claim, but the criminal enterprise is the IGRA violation.
Well, the criminal enterprise is the illegal gambling operating outside of the Indian Gaming Regulatory Act.
Okay.
And your claim under ex parte Young using RICO must, you have to show that RICO itself doesn't provide an exhaustive regulatory framework for how to deal with this illegality, and therefore ex parte Young would allow injunctive relief. Is that your theory there?
Well, yes. Now, again, we believe that the issues that they have raised related to this were raised for the first time on appeal. But could you ask that again? I got turned around.
I'm counting on people to understand things better than I express them. But generally, ex parte Young does not allow injunctive relief when it's based on a statute that provides ample remedies which are assumed to be exhaustive. We have lots of remedies under RICO. If it's not in RICO, you can't go elsewhere to find a remedy, and that would foreclose ex parte Young suits. So you're arguing in part, I gather, that RICO doesn't provide an exhaustive set of remedies, and therefore you can seek injunctive relief through ex parte Young for a RICO violation. Am I correct about that?
Right. Yes, we do not believe that RICO provides the sort of a comprehensive scheme. In fact, the remedies are to be left to us to see. The comprehensive scheme under the, excuse me. I'm sorry, Your Honor.
Yeah, you're not seeking damages.
We are seeking damages, treble damages. Against the individuals, not the tribe. Under RICO, we have not sued the Fort Sill Apache tribe. It's the officials of the tribe and the gaming officials who have worked to operate and continue to operate the casino.
In their individual capacities?
Yes, in their official and individual capacities.
Okay.
And can I interject with one question about the ex parte Young theory against the tribal officials in their official capacities? As I understand it, the people that you have sued are members of the gaming committee and the business committee that voted as a part of a collective body to approve the commencement of gaming in the casino. But typically you have to have an ongoing violation, and you have to sue individuals that that are part of that ongoing violation. These individuals seem to have voted at a discrete time. I don't think there's any allegations in the complaint that they have ongoing enforcement responsibilities, anything to do with the oversight of the casino. So why are those appropriate individuals to have been named in their official capacities under Ex parte Young when they did not participate in an ongoing violation? They participated in a collective vote at a discrete time that is long past.
Well, the individuals, not only did they authorize the establishment of this casino, and you cannot lawfully authorize illegal conduct. That's one reason we believe that they're outside their sovereign immunity, and we can bring these actions, but they continue to operate this illegal operation.
These individuals?
The individuals continue to be involved in the oversight and operation of the illegal gaming operation. So there are cases in which there have been a finding that the fact that there's a regulatory agency involved is sufficient to demonstrate that they continue to be involved in the operation of the illegal conduct.
Well, Councilor, your time has expired. There don't seem to be any further questions from the panel. Am I right about that? So Councilor excused and the case is submitted. Shall we go ahead with the final case of the day, or do we need a break?
I'm okay.
Can I have 5 minutes?
5 minutes? Sure.
5 minutes, I'm sorry.
Take a 5-minute break. Thank you.
Court is in recess for 5 minutes. The Honorable Judges of the United States Court of Appeals for the 10th Circuit.
Thank you. We're ready to start our final oral argument of the day, 24-8017, Parkhurst versus Shannon. Ms. Cassis, did I pronounce that right, I hope? Yes. Thank
the Honorable Judges of the United States.
Good afternoon, Your Honors, and may it please the Court. Layla Cassis on behalf of Appellant Derek Parkhurst. I plan to reserve 2 minutes for rebuttal. The District Court below erred in granting summary judgment to Ms. Stinson on both of Mr. Parkhurst's First Amendment retaliation claims. With respect to the first claim, the District Court erroneously erred in holding that a threat of termination could not constitute an adverse action. On the second claim, the District Court erred in applying the so-called checkmate doctrine discussed in dicta in Raquena versus Roberts, which was in clear contradiction with the correct causation standard, which looks only to retaliatory motive as exemplified in Smith v. Meshner. This court should affirm that the but-for causation standard applies. In the alternative, should the checkmate doctrine apply to the second claim, it requires both some evidence and due process to be otherwise satisfied. Here, due process was violated at Mr. Parkhurst's disciplinary hearing because he was denied 1, access to surveillance footage, 2, the ability to call critical witnesses, and 3, a neutral, impartial hearing officer. On the first claim, I note that the first and third elements are not disputed by Ms. Stinson. And of course, a threat of termination would easily chill a prisoner of ordinary firmness from continuing to engage in First Amendment activity. The court has explicitly held that outright termination of a prison job constitutes an adverse action in Milligan versus Archuleta. It would make little sense to allow the government to threaten what it cannot do outright. And this court has essentially held in Tachias that a threat of a civil action is just as chilling as an actual civil action. And we also would like to note that a threat of termination would actually be more chilling than an actual termination in some ways, because the threat endures and can be leveraged repeatedly against the prisoner.
Does it matter what the language of the threat is? I mean, it wasn't explicit at all in this case. You're inferring that he was threatening. I can't remember the exact language, but it wasn't "get out of here or you're fired."
There's two pieces to the analysis here. The first is a legal question, and that's whether a threat of termination constitutes an adverse action, and that's the question that the court can answer here. The second question is a factual question, and that's whether what Ms. Stinson stated rises to the level of a threat of termination. The district court had already held that Mr. Parkhurst had submitted enough evidence in the record that that was a factual dispute that a jury would decide. So in terms of what Ms. Stinson said, there's enough evidence in the record that Mr. Parkhurst essentially understood what was stated was a threat of termination.
Didn't the district court conclude that the threat wouldn't have deterred or chilled the activity of Mr. Parkhurst?
The district court essentially...
In other words, didn't the district court already resolve the fact question against your client?
District court, in analyzing that element, looked subjectively to determine whether or not Mr. Stinson would be chilled, and stated that because he filed a grievance, he was not actually chilled. And the element is a objective standard. It's whether an ordinary prisoner in this context would be chilled. And here, at issue is whether a threat of termination would constitute an adverse action. And there's sufficient evidence in the record that that was a threat of termination.
Can we decide on this appeal the objective aspect of it? If it's an objective standard, can't we reach that here?
Absolutely, Your Honor. This court can determine whether a threat of termination in a broader sense can constitute an adverse action. And I'm
saying whether this threat was objectively chilling.
The court can look at the facts in the record here, and the court can determine whether there's sufficient evidence to create a dispute of fact. And here, Mr. Parkhurst testified at his deposition that he understood that that was a threat of termination based on the context, the tone. And so there's sufficient evidence in the record that Mr. Parkhurst understood that that was a threat of termination, such that that's a question for the jury to decide.
But it's not just his perception of the threat, it's whether the threat would chill a person of ordinary firmness in pursuing the complaint.
Of course, and
so we don't care about Parkhurst's subjective reaction. It's what an objective observer would have reacted to.
Of course, and that merely colors the inquiry that at least some prisoners would understand that to be a threat of termination. I'll also point to the court that a threat of termination in the public employment context constitutes an adverse action, and there is no reasonable reason stated here why that understanding would not apply in the prison context.
Can I, Ms. Casas, can I ask about that and push back on that a little bit? Does this and let me start by asking this: do the circumstances involving this kitchen job bear on this objective inquiry of chilling an inmate of ordinary firmness from making a report? In your brief, you make a very eloquent, very persuasive argument about the importance of prison jobs. People need this. Well, the only fact that in reading the deposition testimony in the summary judgment record is that he had worked at this job for 4 months. Some of the things that I don't know that a district court, even reasonably considering the evidence in the light most favorable to the plaintiff, would have any basis for speculating is, did everybody at this prison get a job? Was the kitchen job the bottom of the barrel, so to speak? Did he get this because he put in for being a carpenter and everybody wanted to be a carpenter and only the losers really got to be a kitchen worker? Was this boss, Miss Denson, was she someone that nobody ever wanted to work for and poor Parkhurst got assigned to her? So in light of the dearth of evidence about the circumstances, whether this is an attractive or unattractive job, do those bear on the objective inquiry?
I think of the inquiry in two steps. And the first is the initial legal test. And I don't think of that as taking into account of what kind of job it is. And you think of that in the employment context, in the public employment context. You don't ask, is this a government janitor or is this a government high level official, and whether being fired from that job?
Maybe we should. See, I'm uncomfortable with your rigid division between the legal issue and the factual issue. Judge Bacharach pointed out this is very different from your usual job firing. When you're fired, you don't work for that employer anymore. Here you have an institution that'll do something for you, and they want to get useful work out of these people. So being fired from that job doesn't mean it. There's also the question of the ambiguity of it. Yes, a jury might decide, yeah, we think by preponderance of the evidence, this was a threat to fire. But it was an obscure threat, or could be viewed as an obscure threat. And that's not as forceful. That's not as fear-inspiring as a direct threat that you're going to be fired. So depending on how severe the threat is, how clear it is, what the consequences of it would be, may make a difference regarding whether a reasonable person would be deterred from it. So I deal with that as you may, but particularly given Judge Bacharach's insights just now, I think it's more complicated than just saying, is a threat of firing. I'm talking too much. Go ahead and respond.
I think that's a great point. And when you look at the case law, Banton books, it just talks about a threat of invoking legal sanctions. It doesn't discuss what those legal sanctions were. If you look at Tachius, it's a threat of a civil action, but it doesn't discuss what kind of civil action would be at issue. And if you look at Ware, it talks about a threat of criminal prosecution, but it doesn't say what you would be charged with, jaywalking or murder. And so it doesn't matter what the actual context of the threat was. The preliminary question is whether a threat in of itself, whether it's a direct threat, you are going to be fired, or a more indirect threat here constitutes an adverse action. And then it's up to a jury to decide whether or not they find that sufficiently to be a threat of an adverse action. I'd really like to discuss the second claim, if I may, whether Raquina applies or not. And I want to flag for the court that the first and second elements are not disputed by Ms. Stinson here. The lodestar of a causation inquiry is motive. In every other type of First Amendment retaliation claim, we're always looking at what the official's motive was, whether they would have taken the adverse action absent a retaliatory motive. Here, the question normally would be whether Ms. Stinson would have filed the disciplinary charge absent a retaliatory motive, not whether Ms. Stinson would have filed the disciplinary charge absent there being some evidence and due process satisfied at the hearing. The plain text of Ware and the First Amendment retaliation claims on this element merely provide that Mr. Parkhurst has to show that the defendant's adverse action was substantially motivated as a response of the plaintiff's exercise of constitutionally protected conduct. Ms. Stinson is always welcome to argue to a jury that she would have made the same decision to file the charge absent an impermissible motive. And I want to quickly touch on why the checkmate doctrine of the 8th and 11th circuits, which is a minority decision, is fundamentally incompatible with the normal causation standard and is not a application of the normal but-for causation standard as exemplified in Meschner.
Maybe the minority view, but you've got to explain why we shouldn't follow our precedent that did apply the checkmate doctrine.
First, the doctrine looks exclusively to whether due process was satisfied at the hearing with no inquiry as to why the official filed the charge in the first place. So you can have a fully retaliatory charge and that passes due process muster, and that doctrine would say that that prisoner doesn't have a claim. And the second point is that
you're criticizing what we said. Why don't we have to follow our precedent that relied on the checkmate doctrine?
I'll finish up with
you could make a good argument for en banc review on that ground, but this panel can't help you.
And that's why that discussion in Raquina is completely dicta. If you look closely at the opinion, you'll see that the court explicitly provides that collateral estoppel had already prevented the court from relitigating that First Amendment claim. And collateral estoppel is a threshold inquiry in the same way that the court would analyze standing or mootness. And because the Kansas Court of Appeals had already reviewed that prisoner's First Amendment retaliation claim and looked at all three elements and held that there was no evidence of a retaliatory motive, the 10th Circuit cannot, the district court and federal courts cannot come and relitigate the claim and state that he also fails on one of the elements because the claim was already relitigated, litigated by the Kansas Court of Appeals.
You raise a pretty fundamental issue. If we state alternative grounds for ruling, either ground could be considered dictum. They didn't have to, the panel didn't have to address collateral estoppel because it relied on the checkmate doctrine. So the collateral estoppel part of our opinion is just dictum in that regard. How do you decide which of the alternatives is dictum, or are they both dictum? Or are we just wasting time if we give more than one? Go ahead.
Absolutely not. And typically a court will look at multiple elements of a claim and say, you can't meet element 1, and in the alternative, you can't meet element 2. But collateral estoppel is different because it's not an element of the claim. It's a more broader understanding. It's a threshold inquiry, the same way you would look at standing, mootness, and ripeness. So
I'll bet I could find cases of ours where collateral estoppel was raised as a defense and we don't address it because we say you lose on the merits. So it's not, go ahead.
And I'm happy to provide case law on that basically asserts that's a threshold inquiry. From the Ninth Circuit, I have offshore sportswear, and that's 114 F3rd 848.
If they're not in your brief, you can supplement it with a 28J letter. You don't need to recite the cases here.
Absolutely. And to go back to my second point, the doctrine would allow an official to file a disciplinary charge for minor infractions a prisoner may have technically committed and use that as a pretext for retaliation. With that, I see my time is out. I respectfully request that this court reverse on the grants of summary judgment.
Thank you, counsel. Case is submitted. Counselor excused. Court will be in recess until... Whoa. I'm sorry. It's about time I cut you off, though, Judge Bacharach. So go ahead. I apologize. Did you want to ask a question?
No, it's Mr. Miller. I don't think has had a chance.
Oh, my gosh.
But
there you go.
Ms. Cass doesn't object to Mr. Miller not talking, right?
Gee, and I've sat on one fewer cases than the others, and my mind is already gone. Mr. Miller, would you like to say a few words?
Yes, I don't know that they're worth hearing. My name is Timothy Miller. I'm a Senior Assistant Attorney General, and I'm here representing America Stinson, who is a food service worker at a Wyoming prison. There are two claims in this case. The district court correctly granted summary judgment on both of them. The first claim involves an alleged statement to hit the road if you don't like it by Ms. Stinson to Mr. Parkhurst in March of 2021. And after making that statement, Mr. Parkhurst went right out and grieved Ms. Stinson for allegedly requiring him to serve bad ranch dressing. And he has made a retaliation claim based on what she said. The second claim is the issuance of a disciplinary write-up by Ms. Stinson, allegedly in retaliation for some information that Mr. Parkhurst had complained about the ranch dressing. I plan to address claim 2 first because of the court's questions. However, I will spend a moment on claim 1, and Judge Bacharach has hit, I think, a principal point in this case. On claim 1, the second element requires a plaintiff to show that the defendant's actions caused him to suffer an injury that would chill a person of ordinary firmness from continuing to engage in protected activity. We have no description of an injury here anywhere.
Well, can I test that from your perspective for Ms. Stinson? As Ms. Cass has noted, we typically, with public sector employment, some of the cases that she's mentioned, we typically don't talk about, well, was this, job as a sanitation worker, was it a job that the person really cared about? And we do view the evidence in the light most favorable to the plaintiff. And so we do know that he had worked every day, according to his testimony in his deposition, I think, every day in the kitchen for 4 months. So if we view the evidence in the light most favorable to the plaintiff, if we do infer that well, if you don't like it, you can hit the road, if that was a threat of termination, why couldn't a reasonable fact finder, viewing the evidence favorable to the plaintiff, reasonably infer that that would chill a person of ordinary firmness, maybe not a person like Mr. Parkhurst, himself, subjectively. But why isn't the fact that he worked every single day for 4 months enough to chill a person of ordinary firmness?
Well, Your Honor, I don't think it does. It's a vigorous standard for chill the ordinary firmness. And I respectfully submit that what Mr. Parkhurst in fact did does provide some evidence as to what a reasonable person would do, whether a reasonable person would be chilled. And in the Shiro case, 510 F 3rd 1204, this court did make reference to the fact that a man who'd been limited in some way in speaking at a city council hearing had continued to speak at city council hearings and had not been inhibited. This court has found that harassing an inmate all night, calling him a dumb Indian, as a matter of law was insufficient to chill an inmate or a person of ordinary firmness from engaging in the protected activity. And so, based on that authority, a stray comment of this kind, and let me also distinguish this case from Paisley, which is cited by plaintiff in the supplemental reply. In Paisley, the defendant said, if you file a grievance, I will have you transferred out of the unit, you will lose your job, and you will have your ass transferred so far up north that your family won't recognize you when you get back. I think the nature of the comment makes a difference in making a determination as to whether it would chill a person of ordinary firmness. And I don't know that, I don't think the record contains enough information about the performance of this particular position to raise an issue of fact on the point that the court raises. I would just say on claim one, the district court correctly granted summary judgment, ruling that the comment by Ms. Stinson would not chill a person of ordinary firmness, applying that standard. Now turning to claim 2 and the questions that the court asked. And I am in the uncomfortable position of suggesting to the court that it asked a bad question. The parties agreed that a due process analysis does not have any place in a retaliation claim, and there's good reason for that. They are entirely separate constitutional provisions under entirely separate amendments. The elements of the claims are entirely different, and most fundamentally, due process only applies if you have a liberty or property interest. That is an underlying requirement. And so to just thrust a due process analysis on a retaliation claim without regard to whether due process would even apply in the proceeding seems to me to not make sense. And I would make this point about Requena, which I may not have made strongly enough in the brief. In Requena, there was a Requena 1 in which a petition for habeas corpus was rejected by the court. There was a due process analysis in Requena 1 because it was a loss of good time credits under Kansas law that provided a right to that benefit. And so due process did come into play in that case. In this case, it is the Requena standard, which by its express language does not include due process, but in any event follows from but for causation. We are going to have this argument inevitably at trial. Plaintiff is going to have to show that he would not have been sanctioned. He would not have been written up, but for a retaliatory motive.
Okay,
And
let me
so-
ask you, but can I ask you about that, Mr. Miller?
Yes.
This is one item that I don't think Ms. Cassis got to, but it's certainly in her brief. Now, she argues that Requena is inconsistent with Smith versus Mashner. We have precedent in our circuit that when there's an intra-circuit inconsistency of presidential opinions, we abide by the first one, with the theory being that the second one was incorrect because no panel can overrule another panel. In 2018, and I did join Requena, but there is no reference to Smith versus Mashner. I don't think you had an opportunity in your briefing to explain how Smith versus Mashner can be reconciled with Requena. So I want to give you a chance because I'm struggling to see whether or not we made a goof up in Requena by overlooking Smith versus Mashner. How can they be reconciled?
Well, I think they can be reconciled because Smith versus Mashner recognized the but-for causation test, which I think is what the Requena holding ultimately should flow from. But we didn't
certainly say, I wasn't on the court when Smith versus Mashner was decided, but the circuit in Smith certainly didn't say anything that suggested that if the person is punished for an improper motive, no harm, no foul, because they could have been punished because there was evidence, some evidence under Superintendent versus Hill to support the disciplinary infraction. I mean, that's nowhere in Smith versus Mashner. So it seems that Requena included that. That's the very point that you're relying on and that the district court relied on. And that seems to be including a requirement that is absent from Smith for the very reasons you just mentioned. In Smith, it was simply but-for causation, not the existence of an additional theory that there was an evidentiary basis for the infraction, even if it was imposed for an improper purpose.
Well, Your Honor, to my recollection, the argument about the effect of the disciplinary finding was not raised in Smith versus Mashner. And so I don't believe...
Excuse me, what was it raised? What was it raised?
In that the effect of a disciplinary finding against the inmate, to my recollection, was not raised in Smith versus Mashner. It is not entirely on all fours where the court said we're not going to adopt this rule and then later on adopted the rule.
Did Smith v. Mashner, let me ask you about Smith v. Mashner. Did the court in Smith v. Mashner say that there was a denial of due process at the hearing because there wasn't, there was deprivation of a witness or something like that? Do you recall if that was the case in Smith?
I do not recall, Judge. I apologize. I do not apologize. I apologize. I don't recall anyway a due process analysis coming up at all in Smith versus Mashner. And so I would say that the decision in Requena is not inconsistent because it is an additional issue that was not considered in Smith versus Mashner. That is the position that we would take. And Requena, I think, is absolutely governing. There is a case in terms of the Requena somehow being dicta. This court has held that collateral estoppel does not raise a threshold question as to jurisdiction, specifically in Keller Tank Services, which is at 854 F 3rd 1178. Collateral estoppel is an affirmative defense, unlike mootness. The invocation of collateral estoppel to support a position on the merits does not introduce any jurisdictional element into the case. And so what we have is exactly the point that Judge Hart's made. Nothing is binding if there are alternative rulings, because neither one of them, if you could use one to resolve it, neither one of them is binding. Requena is binding. It does adopt the rule. It doesn't refer to it as a checkmate rule, but Requena is very clear, and I think it is important to separate the due process analysis. I think the requirement of evidence follows from but-for causation. If the sanction is not just found, there's evidence to support it, it would have happened anyway. I do want to mention...
Can I ask you a hypothetical question? What if Ms. Stinson said, you know, I'm tired of your back talk on these, you know, on this. You're not, you're not complying with my directive. That's insubordination. And besides, you're a darn, pick your pejorative for a minority. Hispanic, Jewish, African American, whatever it is. And the person says, Ms. Stinson fired me because she specifically included a pejorative reference to my religion, my race, my ethnicity. And then the district court said, well, you were insubordinate. There is, it's a very minimal standard under Superintendent versus Hill. There just has to be some evidence. There's some evidence that you were insubordinate. So it didn't really matter if Ms. Stinson, you know, fired you, you know, partly because you were Black or Jewish or Hispanic, because, you know, there was some evidence that you were insubordinate. Is that your understanding of what our law is and should be?
Judge, and I apologize, I can't recall the case. I believe it is the 10th Circuit decision. A noose, an African-American inmate, there was a noose somewhere in his vicinity, and I believe the court ruled that that was not sufficient to be chilling. In terms of the court's direct question, we're now kind of blending a little bit. I'm not exactly sure that a claim about some kind of discriminatory comment, does that give rise to something else? I'm not sure about that. But I would say that that if insubordinate, if the violation is found, it flows from but-for causation, and there is no retaliation claim. And let me just, and I know I'm over time, but
well, it was my fault. Sorry.
No, it's always my fault. The alternative to this is an inmate files a grievance, and then everything is fair game. He or she can violate any rule. He or she can smuggle in contraband, can be found to have done it, and he still has a retaliation claim to go forward. So there is an opposing policy view on this. And the last thing, if I could just indulge for 20 seconds, this principle is somewhat like Nieves v. Bartlett, in which the U.S. Supreme Court dealt with retaliatory arrest and said it is really difficult to determine whether it was this retaliatory motive or the possibility of criminal conduct that motivated this arrest. And so we have determined that you have to show an absence of probable cause, plaintiff does, to go forward with the claim. This is somewhat similar to that. Whereas it is difficult to separate out retaliatory motive from the actual conduct, and a rule that if you are found guilty of the conduct and there's evidence to support it, serves the same function as probable cause in the retaliatory arrest context. And unless there are any other questions, I will stop.
Thank you, counsel. And it's totally my fault that you went over, because if I'd stuck to my guns and not let you speak at all, you could not have gone over time. I was hoping I could say that my error was harmless, because you didn't say anything worthwhile, but you said lots that was worth listening to. And
well, thank you. I appreciate that. I was going to express some doubt about the harmless error analysis, but thank you.
And that goes for Ms. Cassis too. Thank you for your presentations here today. Cases submitted, counsel are excused. And if it's all right with Judge Bacharach, I'm now going to recess the court until 9 tomorrow morning.